right, what do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God!
We are federales. You know, the mountain police.
If you're the police, where are your badges?
Badges? We ain't got no badges. We don't need no badges. I don't have to show you any stinking badges.
Good morning, good afternoon, good evening, good night, whoever you are, wherever you are, whatever you're doing, whoever you're doing it with, however good it feels, how many times you've done it, how many more times you're going to do it, why you're even doing it in the first place. I'm just glad you're doing it right here with me. Legal Vices, today known as YNW Law Act. We are here and we are dealing with the YNW Melly double murder trial. Rap sensation YNW Melly has been charged with two counts of two counts of murder. It's a double murder trial. First trial ended in a mistrial, and the new trial must get underway by Monday. I mean, jury selection must start unless some things go down today, because today is a motion to dismiss. That's right. The defense is looking to have all of the charges against YNW Melly dismissed for a number of reasons, dealing with the prosecutorial shenanigans. And that's what we're going to be looking at today. We're going to be watching the motion to dismiss, but we've got some things to do beforehand. We've got to catch up on some things. The court's supposed to start anytime now, so we'll get through as much as we can before then. We don't have time to be late. We don't have time to do anything. There's no drink of the day because tomorrow morning is effing Friday. We'll talk about that in just a quick second. But let's get started by bringing up our guest for today.
Hey.
It is Megan Fox. Good morning, Megan Fox. How are you?
Good morning. I've missed you. I feel like I miss you when I don't see you, Jeff.
It's been ages. It's been like
hours. I missed
hours.
You last night. It's been hours since I've seen you.
It has.
I really missed you yesterday on the last night when we watched the deposition of Dr. Sally Smith, child abuse doctor in the Kowalski case. I missed
Watched that. I was so infuriated watching that on the replay.
So infuriating. How did you like the beginning when they tried to pull that shenanigans with that witness?
I don't know why the lawyer hasn't been sanctioned. I just don't know.
I don't either. I think the judge is crazy. But anyway, this is a different trial, and I'm excited about this because
we've got some great. Yeah, okay.
I told you, I was like, Jeff, I got to join you on this. There's nothing I like more than prosecutors getting caught with their pants down, and this is the best example of that I've ever seen. So tell me, because I don't know what happened. How did the prosecutor tell me what happened? She got kicked off. So I want to know. Catch me up.
Well, this is what we talked about last Friday. Last Friday, we watched the motion for the defense filed a motion to recuse the entire prosecutor's office. Mm-hmm. That's what we watched. And that was an off the hook hearing. I thought it would go 20 minutes. It ended up being like a whole thing. It went the whole day.
My favorite part was when the judge was like, "Where is she? Go find her. Make a phone call. Because I want her in my courtroom."
This whole motion is about her.
Oh my
God. In a quick background, so what happened was the lead prosecutor, she got in trouble because another woman in the prosecutor's office who, I mean, this is the wrong prosecutor to pull crap with, because she, for the last 20 years, yes, Prosecutor Boutros, not to be confused with Boutros Ghali, former UN guy. But anyway, Ms. Boutros, she has spent the last 20 years of her life prosecuting officers and prosecutors who have engaged in criminal misconduct.
I was thinking being in the public corruptions office is like my dream job. I want to be in the public corruptions office. I would be after those jerks. I'm telling you.
And that's apparently what happened. The lead investigator, the lead detective in this case, the guy that gave all of the important evidence in the first trial, the guy who signed off on almost all of the affidavits that were the basis for almost all of the search warrants that were executed in the first trial, decided that he was going to commit misconduct in front of the lawyer whose job it is to prosecute misconduct. And what happened was they were trying to serve a search warrant on YNW Melly's mother. The way it was done procedurally was incorrect and illegal, and he needed a witness there. So he told another officer, when it's time to sign this document, just say you were in the room. And the officer responded, according to Ms. Boutros, the other officer responded, I was there if you needed me to be there. And she reported it as she was supposed to do. She reported it to the lead prosecutor, who is the subject of the shenanigans last week and the court's order today, Christine Bradley. Boutros reported it to lead prosecutor Ms. Bradley. Ms. Bradley did nothing, and this was before
sat on it for a year, and then had the trial. Oh my God!
She had this information that allegedly the lead prosecutor, I mean the lead detective, had committed these improper and illegal acts, frankly, falsifying information and manufacturing evidence in the form of a falsified affidavit and encouraging others to do that as well. The other officer and his that got together said, oh, it was just a joke. We were just joking. But
they decide who was joking.
The guy is the subject. The guy quickly became the subject of an internal affairs investigation. So the lead detective, while he is under an internal affairs investigation and has apparently in the presence of another prosecutor solicited another officer to file a false report and to falsely swear an affidavit and then executed an illegal search warrant. The lead prosecutor knew this. She sat on it.
It's unbelievable.
And they're required, the prosecution is required, whether they're asked to do it or not, they're required by law to turn over any information that's available to them that could possibly be beneficial or helpful to the defense to disprove the evidence. I mean, either evidence that shows he could not have done it or evidence that goes against the credibility of one of their witnesses. And the lead prosecutor, the lead detective was the star witness, and they had evidence that he was a crooked cop, perchance. And he was in the process of being investigated by internal affairs. They never mentioned that.
It sounds like everybody in the whole damn DA office knew about it. It went all the way to the top.
It did, and that's the issue that they had last week with this motion. They said, okay, Boutros reported it to Ms. Bradley. Ms. Bradley sat on it, may have mentioned it to her other superiors, went all the way up to the top elected prosecutor in the county, the state's prosecutor for that county. I can't remember what his name was, but the prosecution said, look, here's the problem. One, they didn't turn over this evidence, which is a clear violation of law. And two, when they have the retrial, they have to put this detective back on the stand because he's the guy that is the main witness for them. And when they put that lead detective back on the stand, they are going to call the prosecutor to testify.
They could call 17 people in the DA's office. 17. They could call them all as witnesses, which I think they should. And wait, so are you telling me
we're getting there?
They had he ruled on the motion to boot all of them and only booted one?
Well, we'll get there. Just a second.
Right. Sorry,
we're working up to it. So
shut up, Megan.
So when they put the lead detective on the stand, when the prosecutors put the lead detective on the stand, the defense said they are going to call the lead prosecutor, absolutely going to call her as a witness for the defense to call into question the credibility of the prosecution's lead witness. And as should have happened in the Zachariah Anderson case, but didn't happen for some weird reason, if a prosecutor is a witness, or if there is, even as the judge said in this case, even the possibility that they could become a witness, then they cannot be on the case. They cannot prosecute the case. And as Megan mentioned, they also tried to have everybody else in the prosecutor's office, the local prosecutor's office, thrown off the case. And during this past week, they've had hearings on these motions to quash, which is basically the prosecution saying, we don't want these certain people to be subpoenaed because, for whatever reason. And the judge ruled on those. And today, just I guess about 13 hours ago, it's today for me, yesterday for most of you, the judge issued his ruling on the motion that was argued last week, the motion to recuse everybody in the prosecutor's office. And this is, why is this not here? Aha, I do not know why this is not here. Oh, damn it, we're on the wrong frickin' browser. This should be interesting later. Hopefully it won't buffer on us. But we'll see. Because Chrome is asshole. All right, let me just transfer this.
The chat says, JD Buck says, who will complain to the Florida State Bar Association? Let me tell you something. It won't make a damn bit of difference if they did. The Bar Association is corrupt as hell. The Bar Association never goes after attorneys. Never.
They have intercoursed this, though, in the fact that the prosecution, the lead prosecutor pulled this crap on the woman whose literal job it is to prosecute people who do this stuff.
Well, they should all be charged. I think it's interesting that the defense is claiming that they committed felony level offenses.
Yes.
You guys have to, this is huge.
The defense lawyer accused the state's attorney of committing a felony.
It's huge.
So this is the judge's ruling on this earlier today.
He gave this earlier today. Did we get this
like 12, 13 hours ago?
It
wasn't streamed apparently. We just get this.
I wanted to hear. Oh, there's audio? Or no, that's just the article. The article.
A Broward judge removed. It's in big enough so y'all can read along here. Here we go. No, go away. We don't need you. Stupid frickin'.
Oh, I hate those.
Now I gotta ensmallin it, close it, make it bigger again. All right. A Broward judge removed the lead prosecutor from the Jamel YNW Melly Demons double murder trial retrial Thursday, leaving the state's attorney's office with just a few days to replace her before jury selection must begin.
I can't believe they're going ahead with this trial.
They have to. Because YNW Melly did not waive his right to a speedy trial. And therefore, under Florida law, they have 3 months from the date of the previous mistrial in which to bring.
There are grounds, I tell you, to dismiss this case.
Well, that's what we're talking about today. That's the motion there. If it's not dismissed today, jury selection starts Monday.
Shit.
So this is the last motion. So yeah, they have 3 months from the date of the mistrial to retry him, which means they have to start the proceedings within 3 months of the mistrial. Monday is that 3-month date. So they've got to get a new lead prosecutor in 3 days.
Jeez.
So that's a huge disadvantage for the prosecutor's office going straight out of the gate. They've got to worry about that. So they're at a disadvantage there.
It better not be one of the 17 people subpoenaed.
Well, there are lots of people that are involved in working on the case, but Bradley, she was point. She handled most of the evidence. She handled most of the questioning, most of the cross-examination. She's off. The one who knows everything about this case is no longer on the case. And Assistant State Attorney Kristen Bradley has been listed as a witness for the defense and could be called to, they said she definitely would be called to challenge the credibility of one of Demon's chief accusers in the shooting deaths of rapper.
So I'd make her my whole case.
Yeah. YNW Sack Chaser and YNW Juvie. Circuit Court John J. Murphy said Bradley could not be allowed to serve as a lead prosecutor if there was even a chance she could be called as a witness for the defense. And in the same ruling, to answer Megan's questions, Murphy said elected state attorney Harold Pryor and 2 key deputies cannot be compelled to testify for their defense efforts. To have their office removed from the case entirely, a decision that effectively dashes the defense's hopes that the case will be dismissed entirely. It does severely reduce the possibility that the case will be dismissed, but it's still a possibility. The defense failed to show that Pryor and his deputies engaged in a cover-up that should lead to their disqualifications, Murphy said. All evidence indicates that they told their prosecutors to be truthful to the court and to the defense.
Wait. Hold on. They only
Yes.
failed to prove that though, because the judge didn't drag those subpoenaed people into the courtroom to testify. They would have been able to prove the cover up if those people, the higher ups, were put on the stand, I think.
Well, we'll never know.
I know.
Demon's first trial ended July 22 with a hung jury. By law, prosecutors have until the end of next week. Okay, I thought it was the beginning of next week. So, all right. I thought it was Monday they had to start. I guess it's Friday. Next week to start jury selection in the retrial. Either way, they got to go forward next week. In removing Bradley from the case, Murphy stopped short of saying her integrity had been compromised, but she was at the heart of multiple conflicting statements about what happened last October when Miramar Police Detective Mark Moretti, lead detective in the Demons case, executed a search warrant and seized a cell phone from the defendant's mother during a deposition in downtown Fort Lauderdale. Michelle Boutros, a prosecutor who was with Moretti at the time, said Moretti asked a Broward Sheriff's Deputy, Adam Gorell, to say he was in the room when the phone was taken because Moretti was outside his jurisdiction and had no right to take the phone. So they needed him to be the witness to say, I was in the room when this happened. So the exact exchange between Moretti and Gorell was not recorded, and in 3 disclosures to the defense, the Broward State's Attorney's Office gave 3 different accounts. Bradley gave a 4th account on the stand last Friday at a pretrial hearing. Defense lawyers say Moretti's reliability as a witness is at stake and that Boutros and Bradley could be called as witnesses to prove his willingness to lie and to encourage a fellow law enforcement officer to commit perjury. That's going to take away the credibility of this guy. So there you go. Let's see. Moretti's official report on the execution of the warrant made no mention of Gorell's presence or absence. Although there is no single consistent account of the exchange between Moretti and Gorell, prosecutors contend it was intended as a joke. Yeah, after they get caught, no, we were just joking. We really didn't mean that he should commit perjury and I'm going to manufacture evidence. Clearly we were joking because we would never do that.
Making jokes about that in front of the public corruptions people. That's a great idea. It's like joking about bombs at airports. That's a great idea, guys.
We're just joking, kids. And the last paragraph here, defense lawyer Jamie Benjamin and Daniel Aronson said Demon's defense team does not intend to waive his right to a speedy retrial. Both sides are due back in court Friday for a scheduling conference. It's a motion conference. It better not just be a scheduling conference. It better be the damn motion conference because that's what we're here for. Let's see, how's the court sitting here? The court has not come into session yet. So good. We have some time to go over the motion to dismiss.
Oh, cool.
We have the motion. I have. It's interesting, and we're going to read it again. But first, how are you doing, Megan Fox?
I'm good. Flux is in the chat. Hey, Flux. She says you don't get to make these jokes when a man's life is literally on the line. That's the
literally
thing.
He is facing the death penalty.
The state is trying to kill him, and they have the power to do it. This whole thing is egregious. It is egregious that this happened. And I don't see any other fair outcome than an outright dismissal. I really don't. Making this man sit through another trial while the state continues to try to execute him after we know they did this is so unfair. It's so unfair. I don't know if he's guilty. Yeah. Maybe he's guilty, but it doesn't matter. It doesn't matter. The state has the burden of proof, and they have completely screwed this up. So in the interest of justice, he has to walk, period.
He may very well by the end of this, because they had a hung jury the first time, and now a prosecutor that has only been familiar with the case for a couple of days is being assigned to it. And they're going to crush the lead investigator's credibility. They're going to devastate it. I think he has a much higher chance of walking than he did last trial.
Yeah, for sure. The prosecutor who was kicked off the case, her body language and head movements, is that a tick? So bizarre. I don't know if she was just nervous.
I think it was haughty and arrogance is what I think it was.
She's just constantly with the head movements. That attitude on the stand. Oh man, if they do have a trial and she gets on the stand called as a witness for the defense, whoo boy, I don't think the jury's going to like her at all, because I had an instant dislike to that woman. instantly.
Yeah, she wasn't the best. She wasn't the most likable of people.
Mm-mm.
She was the opposite of likable.
Yeah.
But speaking of people that are likable, we have Victor Mann with the $2 super chat. And the defense summon an interlocutory appeal. It's a retrial. There's there is no appeal. It's a retrial. So they're not appealing any previous verdict.
There's nothing to appeal at this point because it hasn't quite started yet.
Yeah. And see, that's the problem. That's why I don't think there's going to be a mistrial. Because if this would have come out clearly, if this would have come out during the previous hearing, during the previous trial, that this happened, clearly there would have been a mistrial. And I think almost certainly the judge would have dismissed it with prejudice because it was the prosecution's fault. It was their fault that there was the mistrial. Their intentional act caused the mistrial. And if the second trial had started, if they'd even started with jury selection, I think it would have been dismissed and with prejudice, and they couldn't have brought it for the same reason. But here they're in this weird nebulous zone between legal proceedings.
Mm-hmm.
So I think that's going to be the reason why that it didn't cause a mistrial. It was just a speed bump along the way. So I think that's why it's not going to be dismissed completely. But we'll just have to see what happens.
Mm.
Oh, and there's apparently a Steve Gosney sighting somewhere here. Interlocutory would be a waiver of a speedy trial. Oh, are we talking about an interlocutory appeal of the motions that were denied? Or which anywho, it's not going to happen. Baldo Gagger with, where are we at here? We need the we need the ship's bell. Baldo Gagger 4,000 with the $2 super chat, $2 Australian super chat. So they haven't proven his guilt. What charged with? He's charged with double murder, with murdering his childhood friends. We don't know why. It's just the prosecution said they did. He's been charged with double murder. Him and his co-defendant, the driver of the vehicle where the four were last seen alive. Two of them didn't survive. Two of them walked away. But he's been charged with 2 counts of capital murder under Florida. So he's going to be one of the first people, if he's convicted, which I think is pretty unlikely at this point. But who knows? You can never say what a jury is going to do.
I read up on it. It sounded to me like it was really, the details of this murder were really murky. Like it was he claimed it was a drive-by, and I'm not even sure where the evidence comes from that he's the one that did it, because I didn't sit through the first trial. So there's no eyewitnesses. They have one text message, or it looks like a direct message from Melly to someone else saying, "I did it," shh, and that's what they're calling a confession.
Well, for example, one of the big pieces of witness they have against him is the ballistics guy testified that the kill shots were fired from the rear driver's side seat into the rear passenger and the front passenger seats, and that there's video showing Melly getting into that seat before it left the last people to see him, saw him get into that seat where the kill shots were allegedly fired from, and then had the ballistics guy on to show that the bullets that came in from the outside of the vehicle were fired when the vehicle was not in motion, and none of them would have killed the people in the passenger seat. So that's the big thing, but we'll just have to see what they can do now, because now they're going to attack everybody's credibility because of this. So that's what he's charged with, and he's facing the death penalty. If he's convicted, he's going to be one of the first people in Florida, as Mr. Gosney can attest to here in chat, that's going to be subject to the death penalty on the vote of only 8 of 12 jurors.
Yeah, that's a whole thing, isn't it? I don't like that at all. I can't believe they're doing that. Why is Florida doing that? They want to
because the Parkland shooter, 9 of 12 said that that's the way the cookie
you know what? That's the way the cookie crumbles. I'm sorry, but if
that is literally why they did it. 9 of 12 said he shouldn't. He should get the death penalty. 3 didn't. So they said, well, let's take that off the table. Let's make 1 less.
That's
so 8.
crazy. Florida's insane. In some ways, Florida is insane with this. The state is so hungry for bloodlust. I don't understand it. I get. I really am. I'm iffy on the death penalty anyway. I do believe that people who kill children or molest children should get the death penalty, and I also think that agents of the state should get it when they violate civil rights. But that's it. That's it.
Yeah.
I think those two categories. The rest of the assholes out there who murder people and stuff, I think they could spend life in prison. I think that's good enough. Because what if the state is wrong? What if they're wrong? Then you've put someone to death.
Or what if there's corrupt people that are
like the prosecutor in this case? Yeah.
And the lead detective. But we do have another super chat here from Sonia Chris. That's the big one. That's the big super chat. But yeah, that's the big one. Should have just given the little one. But that's for 50 and above. But anyway, Sonia Chris says time to start the run for Doggo Cam achievement. We unlocked the Doggo Cam achievement at $100, but I'm cautioning you to please reserve your super chats wisely, because 11 and a half hours from now is the beginning of my F It Friday stream, where we say F it, and we have a huge panel of guests on that are going to be hanging out. And we're going to go it's a pure griftathon ride. My entire job is to liberate as much money from you as possible, my dear viewers. It's just a pure, unadulterated, boozy, drunken griftathon. $100 shots. We'll have premium whiskey for the $100 shots and a lesser whiskey for the aggregate of $100 that come in. Let's see how much money you throw at me, and let's see what happens to my liver. We're going to go as long as possible until I fall asleep or my liver dies. One of the two. And here is a very, very short, brief list of all of the amazing people that have said yes, they will join. Or I'm sorry, I just saw something funny on Twitter when I was bringing up the list. Oh no, I wish I could show that, but I can't. Oh dear. All right, so here's the list of people that have said yes or a definite maybe for the Grifty Boozathon Fuck It Friday, Friday the 13th, October, Halloween 2023 version. Aussie Overlord, Steph the Alter Nerd, That Star Wars Girl, Chrissy Mayer, Jasmine Jafar, Lauren De Laguna, Lila Hart, Ari Jacob, Nina Infinity, Talk with Sally, AV to the 7th Power, Chandler Remington, Megan Fox, Flux, Lady Law 579, Potentially Criminal, Radix Verum, Waifu Kron Jess, Meme Copium, MG Law, Steve Gosney, Runkle of the Bailey, possibly Nick Ricada, and definitely Nick Star of Trial Watch. That's our list so far. And others will be joining as time permits. So you don't want to miss that. That's where your shekels, dollars, dinero, whatever come in handy. But in the meantime, thank you for all of the super chats we get here during this stream. Baldo Gagger 4000 again. Only Feds and Rock Spiders get the rope. Megan, Rock Spiders.
What's a rock spider?
I don't know. Apparently you said Rock Spiders get the rope, so whatever.
Well, only Feds. Yeah, I definitely only Feds. I don't know what a rock spider is.
I don't know what a rock spider is either.
If it's what I said before, guys who go after kids, perhaps that's what he means. But I don't know. I don't get the inference.
No, Bernice, you're not muted. We see it. We see it. All right. Well, again, court has not started yet, so we're keeping an eye on the court proceeding. So let's look at this motion. Let's take a peek. Let's take a gander.
Yeah, let's.
And I owe Urza's art.
Nobody would subscribe to that channel, Ezra.
Yes. No, see, you owe her an apology too. You owe Urza an apology as well. I've been pronouncing it Ezra forever.
Oh, it's Urza.
Urza, yes, it's Urza, and I apologize to Urza.
What can I say?
Well, I do. I have conditional dyslexia. R's and Z's are a big one. So yes, that's it. It's Urza's art atelier or atelier, depending on where you're from or how you want to pronounce it. OnlyFans. We will be introducing new merch over the weekend. The Give It a Whirl merch. If you're up on that, if not, go back to part 13 of our reading of the Johnny Depp Amber Heard sidebars from Tuesday of this week or Monday of this week, depending on where I guess it was Tuesday this week. And you go to the 50-minute mark and you'll be all over that. It's a fun thing, and Urza has prepared some artwork for that. Right.
Oh, that was so good. Urza's the one who did that.
Yes.
Fan-freaking-tastic. I love the artwork.
The artwork is awesome. It's great. All right, let me bring this up here. Rock, where are we at here? Baldo Gagger again with two more Aussie bucks. Rock spiders bury themselves in small cracks.
Ew.
And we've all been there. Let's bring up the motion. Present screen. Cannot present screen because apparently I closed it. There we go. Let's present screen again. Right. Oh, we can embiggen this. This is the motion to dismiss. State of Florida plaintiff versus Jamel Demons defendant in the Circuit Court of the 17th Judicial Circuit and in Broward County, Florida. Motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights. Not fooling around here. This is a serious motion that the judge very clearly said, very specifically said he is taking very seriously. Let me double check here before we get into the motion. What's going on in law and crime land? Nope, still nothing. Just lots of people in their chat saying, when is it starting? It'll start when it starts. Until then, everybody should get on over here and watch my stream. But don't tell them that because they get upset. All right, comes now the defendant Jamel Demons buy-in through undersigned counsel and moves his honorable court pursuant to Rule 3.190 Florida Rules of Criminal Procedure to issue an order dismissing the indictment in the above styled cause and states as follows. 1. Defendant was tried in the above styled cause from April 10th, 2023 to July 22nd, 2023. The result of that trial, as this court is well aware, was a hung jury. The lead investigator in this case is Detective Mark Moretti of the Miramar Police Department. As such, his credibility is not only germane to this case, but has a direct bearing on the outcome of the case. The jury's estimate of the truthfulness and reliability of a given witness may well be determinative of guilt or innocence, and it is upon such subtle factors as the possible interest of the witness in testifying falsely that a defendant's life or liberty may depend. So again, they're just saying like any witness that just the subtleties of their testimony could put someone in jail for the rest of their life, and therefore whether or not they're credible could end up determining whether or not someone is guilty or innocent.
Mm-hmm.
In this court case in Illinois, the court cited a New York Court of Appeals case, People versus Savidez. It is no coincidence that the falsehood bore upon the witness's credibility rather than directly upon the defendant's guilt. So they'd say, there you go. The lies, the cheating, the whatever is going on, that reflects on the witness, their credibility, not on the guilt or innocence of the defendant. Therefore, under Giglio v. United States and Brady v. Maryland, information, this is the Brady violations and things we're talking about that came from this Brady v. Maryland case in 1963, information within the state's possession that would have impeached the credibility of Detective Moretti, known to the state, should have been presented to the defense prior to trial. Unfortunately, that did not occur. In fact, the opposite occurred. And that's what we were talking about just a minute ago. They had this information that Moretti had solicited another officer to lie under oath, to falsify information regarding the affidavit and the serving of this search warrant, et cetera, et cetera. They knew about it before the first trial. They sat on, and they also knew he was under an internal affairs investigation and didn't bother to mention that to anybody. They sat on it before the last trial, during the last trial, and after the last trial. It only came to light about 3 weeks ago that this had happened. 6, for the defendant to establish a Brady violation, the defendant must show 1, the evidence was favorable to the defendant, either because it was exculpatory, it would prove that he didn't do it, or because it was impeaching of the witness. It was suppressed by the state either willfully or inadvertently. We didn't know is not a good excuse. We thought we did it, or we meant to do it. That's whether you do it willfully or inadvertently. If you suppress that, if you don't know it exists, that's different. But if you know it exists and it doesn't find its way to the other side, there's really no excuse for it. It was material. 3, it was material thereby causing prejudice to the defendant. Well, although the state has an obligation to provide Brady material, nonetheless, on July 25, 2022, the defense filed a Brady request. So they're saying we don't even have to ask. They have an affirmative obligation to do this. They have to turn this stuff over whether or not we ask. But just to be helpful, on July 25th, 2022, we filed a request for any other information that they have not turned over yet. And they didn't do it. The defense has been requesting of Assistant State Attorney Christine Bradley information in regards to the investigation as to what occurred when the phone of Jamie King, the defendant's mother, was seized. The responses have been simply, there are certain named witnesses under investigation. Well, on October 23rd, 2023, so again, that was like a month ago, I guess a little over a month, 5-6 weeks ago. On August 23rd, 2023, the defense served another Brady request. This was for information in regards to the investigation of Detective Moretti for the use of excessive force against Jamie King. On October 30th, 2023, Ms. Bradley responded that an internal affairs has it in Miramar. So then it's like, wait a minute, the lead detective, the main witness in the first trial, is under internal affairs investigation? Well, that would have been nice information to have.
Seems relevant.
Yeah. In fact, on the date of this client's last calendar call on September 22nd, 2023, outside the courtroom, Mr. Adelstein asked the prosecutor what was going on as to any internal investigation with Detective Moretti, based upon seizing Miss King's phone. Well, that ain't good. So, in essence, Ms. Bradley stated that the investigation was closed and no wrongdoing was determined. Ms. Bradley was also asked what the best procedure would be in order to take the deposition of Assistant State Attorney Michelle Boutros, who was present when the phone was seized. Ms. Bradley responded that the office required a subpoena and then interjected that, however, Ms. Michelle Boutros was very ill and at home, certainly giving the impression that she was too ill and infirm to be a part of this matter. Oh, in other words, the best way to deal with her is to not call her at all because she's sick.
Oh my gosh.
Well, she seemed pretty damn healthy when she testified on the stand last Friday. And you could, they called the defense called Ms. Boutros to the stand last Friday regarding this motion to recuse all of the prosecutors.
Testify.
Oh man, there were not enough buses to throw the prosecution under. She kicked ass and took names. She was stellar in her job.
So direct, so forthright. I believed every word out of her mouth.
Yep.
Total opposite of Bradley.
Yeah. So we can pretty much count on her being a witness in the next trial.
I think so. Unless somebody gets to her first. Unless she disappears.
Well, that's also something we might have time to talk about, depending how long it takes for the court to get its act in gear here. Number 14. Ms. Bradley was also asked if we can get Ms. Boutros' sworn statement. I don't think. Ms. Bradley responded that she doesn't have the file. Subsequent to that conversation, counsel for defense learned that, in fact, Ms. Boutros has been working and is available to go into the state's attorney office. Oh, she wasn't, in fact, ill. She was working.
Bradley should be fired and barred from working for the state in any capacity for the rest of her damn life, if not put in prison. Straight to jail.
Yeah.
Look at this lying creep.
Bradley's career should be over. She's not doing her career any favors right now. And then a lot of people have been saying, but what about Boutros? She's going to lose her job because of this. She's pretty much safe because this is literally her job.
She has whistleblower protection, plus she works in public corruption. Frankly, she should be given a promotion. She did exactly what she is supposed to do.
Yeah, that's her job.
Yeah.
So she's pretty much going to be safe. Yeah. Steve Godney says, are you kidding? She's not going to get fired. She's going to get promoted.
Yeah, she needs to
Totally
get
right.
promoted. And
Yeah.
I mean, but really, she's doing exactly what she's supposed to be doing in the public.
No, he's talking about Bradley's not going to get
Oh,
fired. Bradley's
Bradley.
going to get
Oh,
promoted.
yeah, for sure. For sure. That's how they always act.
Yeah.
That's how they always act. That's how they cover up their wrongdoing. They do it at DCF and CPS all the time. You get a caseworker who violates your civil rights and takes your kid with no warrant, they will promote her. They will never, ever discipline them.
It's yeah.
Or appointed to judge, Steve says. Yep.
Yeah.
How it works.
Yeah. Criminal court judge. Yeah, exactly. All righty. Well,
Bradley on the bench. Can you imagine that with those weird head ticks?
God. Well, again, I'm a bobblehead too, but
No,
that just goes back to radio when I could move around and nobody would see me and it just kind of holds over. And what are we getting? All right, here we go. So they've just said, oh, that part where she said that Boutros was sick and ill and unable to come in. Well, in fact, she was working and available.
Survey says that was a lie. Holy shit, Bradley.
The defense has set Ms. Boutros for deposition on Friday, September 29th, 2023. That actually happened last Friday. So counsel for the defense also learned that day. What else did they learn that day? Shall we see? Also learned that day, again, after a conversation outside of the courtroom with Ms. Bradley, that Ms. Bradley, in contravention to statements made to the defense. In other words, she lied to the defense, and she was actually quite involved in this matter, including having conversations with the head state attorney and the assistant to the chief in regards to Detective Moretti. Yeah. Later that day, Mr. Adelstein, by letter attached here too, confronted Ms. Bradley with her less than candor. In other words, they confronted her about her lies.
About her lies.
In response, the attached notice pursuant to Rule 3.220B4 was filed. We'll get to those here at the end of this. Counsel for defendant also noted above, expects to be taking the deposition of Assistant State Attorney Michelle Boutros, who was present during the altercation, and enlightened not only the defense, but ultimately the court on exactly what transpired, as opposed to Ms. Bradley's secondhand hearsay rendition. Mm-hmm. Yes, that was the judge made a point of asking her that repeatedly last Friday. Well, how do you know what because she said, well, this happened. Well, how do you know? Detective Moretti told me.
So you chose to believe a guy who's under investigation for corruption over the prosecutor who was there and witnessed it.
Mm-hmm.
That's crazy. It's just damn crazy. They're colluding. She's colluding with the dirty cop.
And about the whole joking thing,
she's changed her story on that too.
Yeah, Moretti said, according to Boutros, Moretti said, tell them you were here, and Gorel, the other officer, replied, I was there if you needed me. There was nothing about it being a joke ever. Then Ms. Bradley said, they all knew it was a joke. And the question was, how did you know it was a joke? Well, Detective Moretti told me. Well, it's not mentioned in Gorel's affidavit anywhere that he'd said it was a joke or they knew it was a joke. And basically came out with 4 different versions, which were, this is what I understood Morel to say. This is what Morel said. This is what Morel said Gorel said. So basically she was basing her opinion on third-hand testimony from the guys who were being charged with misconduct in the subject of an internal affairs investigation over the anti-corruption prosecutor, which of course led to the question, so you're going to have to, so if this is the whole deal, why she was kicked off the case was essentially this, because the judge was saying, so what you're saying here is if you prosecute this case and they call Ms. Boutros to the stand as a witness, the prosecutor's office is going to have to try to discredit one of their own employees in favor of a police officer who is under internal affairs investigation.
Jeez.
And I said that could be a problem for you. You think? So she had the secondhand hearsay information, which was Gorell to Moretti to her. Regardless, the information provided by Ms. Bradley indicates that Detective Moretti executed a search warrant outside of his jurisdiction and therefore illegally. It would have allowed the defense to question him as whether he committed a robbery or battery on
Holy
Jamie King
shit.
when he unlawfully took her phone.
Mhm.
It would have shown that Detective Moretti was willing to lie as to who served the search warrant, an official court order, and it would have shown that Detective Moretti was willing to conspire with Deputy Gorell to obstruct justice and to create false filings. This was impeachment evidence favorable to the defendant. The first prong of Brady is met. Clearly it's met. I don't want to get too far behind here. Oh, hey, we get the gifted memberships now show up in StreamYard. How awesome is that?
That is awesome.
Finally, geez. All right. Nancy Joe M gifted 10 Legal Vices memberships. If you're one of those awesome lucky people that got the 10 gifted memberships, please give Nancy Joe M a special thanks. And Peace Peony, member for 3 months, says, could the defense use the strategy to let the trial start and then file this motion to force a mistrial? Could they have used that? I guess, but Steve would be the guy to answer this question too. But there might be a timeliness matter where if you don't make the objections timely, you might lose the right to do it. I don't know, but that's an interesting question. I do not have the answer to that. I don't have all the answers. I'm sorry. And official Rogue Ent or official Rogent, depending how you want to pronounce that, with the $5 super chat. Defense got lucky. AF. They know if this goes to trial again, that boy is going to get fried. I'm mad at state for messing up and giving him a chance to be set free.
Well, at least his anger is placed in the right spot.
Yep.
That's who you should be mad at. The prosecutors
violated. Don't be mad at the defense lawyer.
Nope.
Don't be mad at the defense witnesses. Be angry at the prosecution they should be pilloried for this. They should be frog marched around the court and saying, "Look,
be charged criminally for this."
Yeah.
Criminal. This is criminal. Perjury. When did we get to a place in this country where perjury is never, ever, it's never punished? Perjury is just like, they say you're under penalty of perjury, but it carries no weight because no one is ever prosecuted for it. No one. And it happens every damn day.
Yeah, perjury is so undercharged because, again, it basically just comes down to it's not worth the time and the effort.
Well, it is. And this is why it is worth the time and the effort. It's the broken windows theory, Jeff. It's the same thing. Yeah, it seems like a small thing. But it's not a small thing. It leads to massive corruption on this kind of scale because it is not prosecuted. And I like how the chat is saying, unless you lie to the FBI. Yeah, for God's sake, never tell a lie to the FBI. You'll end up in a hole for 2 years with no trial.
Yeah, I mean, see, and that's the problem. I mean, it could be used to crush a lot of these police officers that perjured themselves and whatnot. But again, they go, "Oh, we got all these murderers to try. We can't just be worried about a couple misstatements that someone made."
Perjury
it's crap like that.
Perjury can be compared to murder because look at what they're doing. This is false testimony against thy neighbor. That is on the same list as murder. In the 10 Commandments, thou shalt not murder and thou shalt not commit false witness against thy neighbor. It is the same. You are murdering someone's reputation. You are murdering their liberty. This is comparable, and it's not a small thing. It's a big thing. And I know when I'm around lawyers, they laugh at me and they're like, "Oh, how you're just so sweet and naive." I'm just saying the way things ought to be, not the way they are. Perjury is a big deal, and it puts people in prison. It takes away liberty, and so it should be prosecuted when it is found. Period. Sorry.
You are correct, and I agree with you, but
we're never going to see it. I know.
Well, and I was told that now may be a good time to unveil this. I was told we have to use this as part of our Dep v. Heard streams.
Oh, what's this?
Get on with it.
Yes, get on with it!
Oh, I am enjoying this scene.
Get on with it!
Told we have to use that.
That's funny.
So,
That's funny.
so yeah,
It's
we'll have to
fitting.
deploy that. Yeah, all right. So rather than presenting this to the defense, so that the defense could have used it during the first trial. Again, they knew about this well before the first trial took place. Rather than presenting this to the defense, so the defense could have used it during the first trial, the state withheld this information. In fact, it is believed the highest levels of the state's attorney's office made determinations to not provide it to the defense, and secondly, not to pursue the internal affairs investigation. This was the institutional policy of the state attorney's office, not just one prosecutor. Affirming the denial of the defendant's motion to dismiss, as there was no showing of institutional policies of the state office, is this case here. The evidence was suppressed by the state. The second prong of Brady is met. Now they only have to meet prong 3, the prejudicial prong. The unfortunate stark reality is that the state intentionally withheld this information that would impeach Detective Moretti in order to gain a tactical advantage and to violate Mr. Demon's due process rights as guaranteed by both the 14th Amendment to the United States Constitution and the parallel provisions of the Florida Constitution. Because this withholding of evidence was not only institutional but deliberate prosecutorial misconduct, double jeopardy principles apply and the case must be dismissed. As noted above, this was a hung jury. Normally, the remedy for a Brady or Giglio violation is a new trial. However, the remedy for prosecutorial and government misconduct is dismissal. If it's their fault, they don't get to do it again.
Which is why we won't. Oh, it's finally starting. It's fine. The courtroom is finally on.
Well, the court camera is on.
The camera's on.
So now the heat is on for us to get through this.
I was watching an old trial, a documentary about an old trial in Florida, and it was the same damn courtroom with the marble, the big marble background, and I was like, oh hey. It's funny. It was like from 1990 something, and the room looks exactly the same. They haven't changed a bit of it.
Well, as noted above, this was a hung jury. Normally, the remedy for Brady or Giglio so hung that there's a violation of the remedy for prosecutorial and government misconduct is dismissal. As the United States Supreme Court noted in Pyle v. State of Kansas, petitioner's papers are inexpertly drawn, but they do set forth allegations that his imprisonment resulted from perjured testimony, knowingly used by the state authorities to obtain his conviction, and from deliberate suppression by those same authorities of evidence favorable to him. These allegations sufficiently charge a deprivation of rights guaranteed by the federal Constitution, and if proven, would entitle petitioner to release from his present custody. That's the state that's the judgment they're relying on to make these arguments. Here, certainly the withholding of favorable evidence, whether illegal criminal activity or unethical behavior, requires a dismissal. As the court noted in Cruz v. State, in analyzing this issue, courts must focus on whether the favorable evidence could reasonably be taken to put the whole case in such a different light as to undermine confidence in the verdict. Well, I think when your lead detective is soliciting others to commit perjury and to falsify evidence and affidavits, that could cause you to look at the case in a little different light and undermine the confidence. No one knows the proverbial what if. However, given the hung jury and the inability to cross-examine the lead detective in this case as to his role and desire to skirt or break the law in furtherance of this investigation, it would have changed the outcome. As the court noted in Shepard v. State, moreover, prosecutorial misconduct can constitute fundamental error. Prosecutorial misconduct may so infect the trial with unfairness as to make the resulting conviction a denial of due process. The state has been sitting on this information since October 12th, 2022. November, December, January, February, March, April, 6 months they sat on this before the first trial. They knew this guy was up to shenanigans. They knew this had gone on. They knew he was being investigated by internal affairs for 6 months. It allowed one trial to go by while concealing the evidence.
Elaine came in there for a second.
Obviously, we were planning on allowing another trial to go by without revealing this information. Only after the defense started to uncover what happened on the date between Detective Moretti, BSO deputies, and Jamie King in the presence of Assistant State Attorney Michelle Boutros was the state forced to reveal what it had been hiding. That's strongly worded.
It's true.
Yeah, I mean, it's not wrong.
There's no evidence that all the evidence says they were hiding it.
Yeah. The defense has shown through this motion that the state willfully withheld impeaching evidence against Detective Moretti in order to gain a tactical advantage. However, it is also believed that the state has basically shelved an internal affairs investigation and a possible criminal investigation of Detective Moretti as to this matter. Again, it could have been battery, it could have been theft, it could have been robbery, taking this woman's phone. And possible criminal investigation as to this matter so that it could not be used against Detective Moretti at trial. In essence, the state has intentionally done whatever it could to sanitize Detective Moretti's actions so that they would not be fodder for cross-examination during trial. Although the defense has only uncovered the tip of the iceberg in this matter, the tip is sufficient. Just the tip, only
Just
the
the
tip.
Hey, phrasing. I can't believe they wrote that. Somebody, not a clerk, nobody read that and was like, you might want to rephrase this. The YouTube lawyers are going to have a field day.
The tip is sufficient.
Phrasing.
For the court to determine the defendant's due process rights as guaranteed.
On the merch. That's got to make it on the merch.
The tip is sufficient. Guaranteed by the United States.
That's lawyer speak for just the tip. The tip is
sufficient.
No. Oh, man.
You're never coming on another stream again.
Sorry. I'm sorry. I'll mute myself while I have a breakdown.
Wow. All right. Let's get back on the track here. I'm not going to play that video again. All right. Where even are we, Megan? What have you done to me? I can't even figure out where the hell we are. There we are. Just the tip.
Dismiss
sufficient. This court to determine the defendant's due process rights as guaranteed by the United States Constitution through the 14th Amendment and the parallel provisions of the Florida Constitution, that his fundamental rights have been violated and that the only remedy is dismissal and to let him free. See State v. Glosson. Based upon the due process provisions of Article 1, Section 9 of the Florida Constitution, we agree with the Hohense and Isaacson that governmental misconduct, which violates the constitutional due process rights of the defendant, regardless of the defendant's predisposition, requires dismissal of criminal charges.
I move for a bad court thingy.
You mean a mistrial?
Yeah.
That's Elaine. The third... Yeah. The third prong of Brady has been met. Wherefore, the defendant requests this honorable court grant this motion and dismiss the indictment in the above styled cause. I hereby certify that the foregoing was electronically filed with the Florida court's e-filing portal, and a copy was furnished to all parties of record this 26th day of September, 2023. Here is the letter that was filed with this. State v. Demons from Stuart Adelstein. Okay, this should tell you all you need to know. Adelstein's law at AOL.com.
Who is this guy?
Stuart Adelstein is still using AOL.com as his email.
Who does he work
You've
for?
You've got mail. Well,
I haven't heard this name yet.
Yes, you have. You just weren't paying attention.
I have.
And I forgot. So how's that? We got to go back up here. Adelstein.
I feel like, never mind. I'm sorry I asked. I didn't mean to derail it. Just read the letter.
Yeah. And how the hell do we even spell dude's name? All right. Whatever. Who was he? See, I hate when people ask me these questions because then my brain goes into shutdown mode. Adel.
Adelstein.
Mr. Adelstein. That's who he is.
It doesn't say who he is.
Mr. Adelstein asked the prosecutor what was going on. He's one of the guys. He's one of the bros.
All right. What does this letter say?
What is? He's Adelstein Law Office of Stuart Adelstein. Okay, he's one of the lawyers.
Is he Melly's lawyer? I think he's Melly's lawyer. One of them.
Yes. Yes, he is Melly's lawyer. Yes. Okay. He was one of the first ones here on the shenanigans. Good afternoon. That means fuck you in lawyer speak. This morning before court, I requested a copy of Assistant State Attorney Michelle Boutros' statement to Internal Affairs RE Detective Mark Moretti, since, as per your Brady response, the investigation is closed. You represented to me that you do not have it. After court, I then received information that not only do you have a copy of that statement, but you have a copy of the complete Internal Affairs investigation. Please advise me if you still stand by your original representation before we file any additional motions related to this subject. This is like, okay, here is your last chance. Do you still stick by that bullshit story, or are we going to have to get ugly here?
That weird return is bothering me after you. Who,
I know.
Who
I'm
edited
scrolling
this?
quickly past it.
Who edited that?
Well, this leads to this notice pursuant to Rule 3.220B4 comes now the state of Florida by and through the undersigned state attorney. Pursuant to this rule, Florida Rules of Criminal Procedure submits the following information which is in the state's possession or control, which may fall within the purview of Brady v. Maryland. On October 12th, 2022, on the 7th floor of the west wing of the Broward County Courthouse, Ms. Jamie Demons King statement was taken by Miramar Detective Mark Moretti and ASA Michelle Boutros. Assistant State's Attorney Boutros. Also present was Mr. Robert Trockman in his capacity as Ms. Demon King's counsel, and BSO Sergeant Jason Hendrick. Notice who's not here. Gorell, the guy who said, well, I was there if you needed me to be there.
But he has the ability to just be places where he isn't.
Yep.
So he might have been there. He might. If they needed him, he was there.
During the statement, Sergeant Hendrick left the room. Shortly thereafter, during the statement, while no BSO deputy was present, Detective Moretti executed a search warrant on Ms. Demon King's phone. Detective Moretti seized said phone. Ms. Demons King and Mr. Trockman then left the room. Shortly thereafter, BSO Deputy Adam Gorell arrived at the conference room. According to ASA Boutros, it was at this time that Detective Mark Moretti stated, and mind you, this is coming from the state attorney, the highest elected official in the state's attorney's office in this county. He says Deputy Adam Gorell arrived at the conference room. According to ASA Boutros, it was at this time that Detective Mark Moretti stated to BSO Deputy Gorell in front of ASA Boutros that Deputy Gorell should say that Deputy Gorell was present when Detective Moretti executed the search warrant, seizing Ms. Demon King's phone. According to information from ASA Boutros, Deputy Gorell, neither, it should be a neither in there, according to Deputy Gorell, nor any other BSO deputy was present in the conference room where Ms. King's statement was taking place when the search warrant was executed and the phone was seized by Detective Moretti. The undersigned spoke with Detective Moretti in regards to this incident, and Detective Moretti said he asked Deputy Gorell if Deputy Gorell was there when the phone was seized. Deputy Gorell responded something to the effect of, I can be if you needed me to be. Now, see, there's some bullshit right there. The undersigned spoke with Detective Moretti. So the state's attorney, I'll get note this, the Harold F. Pryor here, and Ms. Bradley. Ms. Bradley, she talks to Moretti and asks him about this. She asked if Deputy Gurrell was there. I mean, how stupid is this? He said Deputy Gurrell, and wait, where did we go here? The Detective Moretti, in regards to this incident. So she spoke with Detective Moretti, and Detective Moretti said he asked Deputy Gurrell. Why would he ask Deputy Gurrell if he was there? He knows who was there because he was in the frickin' room. So this whole, that shows some bullshittery right there. I asked Gurrell if he was there. Why? Nobody can place him in that room. You know he was not in the room when that happened. Oh, we've lost Megan. Hopefully come back, Megan. So yeah, here he's saying, I asked him if he was in the room. He knows he wasn't in the room. And then he said something effective, I can be if you needed me to be. That's some crap right there. I hereby certify that a true copy thereof has been furnished electronically on the 23rd day of September. So they literally found out about this 20 days ago. That is some BS right there. Now, this is what they're arguing today. They're arguing this motion. Steve Gosney says, the scariest thing at Megan Fox is that in my experience, death penalty prosecutors cheat more than line attorneys. That terrifies me, Steve. That terrifies me. How did IA not see that as suspect? Well, what Internal Affairs did, see, if Internal Affairs goes forward with their investigation, then they have to tell that to the prosecution, and then we have all kinds of problems. So what the prosecution is saying is that Internal Affairs, they shelved the investigation against Moretti so it couldn't be used against him to discredit him when he goes to trial.
That doesn't seem right.
It doesn't really, does it? Did you see
No.
Steve Gosney's comment while you were gone?
No, I had to reboot. My computer's doing that thing.
The
again.
scary thing, he said, is that in my experience, death penalty prosecutors cheat more than line attorneys.
That is scary. That's terrible.
Yeah.
That should not be. No.
Really, Megan? Thank you for that insightful knowledge. Really?
I know.
Is that what you're saying?
That's what I'm saying. It's
wow,
wrong.
weird.
Yeah, but these days
they should look into that.
Apparently, these days, it's not common knowledge what's wrong in
What
the
have I done here?
prosecutor's office. People don't seem to have that common, easy knowledge of what's wrong. That framing a guy for the death penalty.
You're gonna win. Hey, the bastard did it. You got to get him one way or the other. If there's not good enough evidence, you plant it there. Of course.
So bullshit. This is why OJ got off.
Exactly.
It's the exact same thing. It's like, just do good police work. That's all you have to do. Do your job, do it correctly, and don't cheat. If you can't find the evidence, well, that's too bad. He got away with it.
You're just asking too much.
Oh, for fuck's sake. I'm so tired of it. What the heck happened to my box of tissues? I had some. Someone stole them. Dang it.
Oh no, what's happened to Megan Fox? Issues.
All right.
All right, just bring up the courtroom so we can all see what's going on here. We'll put
just
this
staring at the marble wall again.
Let's see where should we put this so it is linked to all of these. Yeah, no, that's not what we wanted to do.
How come these things never start on time? Why? Why is that?
I don't know. I'm gonna ask.
I feel like it's really rude. I mean, here we are.
That's not it.
Here we are. We've shown up for this. We were on time, and now they're not. The court is not on time. It's very rude.
Audio Wizard says maybe we need body cams on all government officials.
Yes. Yes, we do. Yep. Already probably stole your tissues. He steals cell phones. Yeah, I wouldn't put it past him.
He probably did. Bastard. Okay, that's
a
all
weird
right.
setup.
I'm just trying to figure out a way where we can put the I'm gonna have to create one on the fly then, I guess. We'll just have to use one of these screens and then edit it so we can put the court feed behind us so we can see
Oh,
when they
that's
start.
cool. How do you do that? Are you on? Do you have like you must not be using just StreamYard then. OSB or whatever the hell it's
No,
called.
I'm using StreamYard, but you can adjust these things.
How
on
did
the
you
fly.
do that? How do you do that? I've never seen that.
You get to do it. It's
I guess
you
I
can
don't
just
know
like
how to
edit
use
things.
StreamYard. I don't know how to use StreamYard as well as you do. But that doesn't surprise me. I don't know how to use a lot of things.
Well, that's not the one we wanted, is it?
Now,
that's less than ideal.
oh, that's not bad. That one's not bad because we can
Yes,
see
it
both
is.
at
It's
the
weird.
same time. It's weird.
Well, I need to delete one of these things
How
here
are you
first.
doing this in StreamYard? I don't understand how you're doing this.
There's like a little edit button down. Check it. I get for chance maybe I can't edit any of these things on the fly. Whatever. We're just kind of waiting here for the court to start doing its thing.
Which it appears
as you can
to not
see.
want to be doing.
Yeah. It's just sitting there. But let's take a look at some of the things that are going on. Yes, ma'am. Go ahead.
Oh, never mind. Go ahead. Let's look.
Oh.
What are we looking at?
Nope. Talk.
Well,
Now's your chance to talk.
I was gonna say, I think that they called Maya Kowalski back to the stand. We could watch some
Wow.
of that while we're waiting, because that's happening now. And I don't know why they called her back to the stand, but she is on the stand. Last time I looked, and she was crying a lot. So that's
Oh, that's not good.
We could watch. Yeah, she's still on.
That's distressing.
I know.
Well, let's look at KRAM here. We got to give you the super chat ships bells. Bradley had a legal obligation to notify the defense, but she didn't talk to the other deputy and file a Brady notification until after the trial ended, when they were basically forced up against the wall to do it. You know, they had this, are you sure you want to stick with your story that you don't have anything else to tell us before we have to go make some other motions? And then, oh yeah, here's the story. They were essentially forced to do it.
Terrible.
And Joseph Nash. How many prosecutors punished for misconduct? In this case, 0. How many in other cases? Statistically close to 0. You know.
No, they usually just get, a strong talking to, and then they get promoted.
I'm going to try something here. Bear with me, folks. We're editing on the fly. What do I?
Here, I just pulled up on a Google search.
Yes.
There's a former Utah prosecutor accused of voyeurism and stalking. So there's what that's like an outside crime. Yeah,
what is the prosecutor's name?
Well, that was 9. This is a new thing. ABC Utah reports that. Here, I'll tell you in a second.
Yes.
Here, hold on.
I'm holding.
Dennis Judd, a former
do not know him.
Something county, I can't read that county, is accused of installing a secret camera in the bathroom of his Vernal law office and recording female employees.
Vernal.
Yeah,
Vernal. Yeah.
So he's being charged. Let's see, prosecutor. Nope, that's not it. Let's see, who else?
Lovely.
That's the only one that came up on the Google search.
What are you searching for? Like bad shit in Utah? Is that what you were searching?
No, I'm just looking for prosecutors charged with anything. Charged with, crimes.
Well, you're going to be searching for a long ass time.
Let's see. Yeah, there's like there's hardly anything. Because the chat wanted to know how often do they get charged or prosecuted. They don't.
They don't, yeah.
A new Texas law could get prosecutors fired for not pursuing charges. Well, that's not what we're looking for.
Well, that's nifty, isn't it?
Here,
See how hard it is to find something?
A St. Louis cop sabotaged his own cases to undermine a prosecutor. He must have really hated that prosecutor. Holy shit.
Okay, I've created a custom layout here. We'll call it Court Can. All right, where is Court Can? There we are. Boop. All right, so now we can see what's going on behind us.
That's fun. God, I should take an allergy pill. My eyes are.
We can
itching now.
also edit it to get rid of the law and crime thing.
How?
Just move down the boxes here.
Oh, that's that's cool.
And everything.
Perfect.
All right. Steve Gosney, Osai, Megan Fox, you've not been reading chat. 6 prosecutors disciplined by Florida bar in the last 30 years. See page 240, ideas and answers in law.
Wow, Steve. That's grim. That's grim.
The main thing lawyers lose their license for, the number one thing lawyers lose their license for, is messing with client funds. That's it. I mean, if there's like a dime that cannot be accounted for, you are in serious freaking trouble with the bar. That's the quickest way to have your license yanked in any state in the union, is to mess with client funds. That's pretty much it. That's, or in like crimes, committing other crimes, like financial crimes, drug crimes, even drug crimes. They're lawyers helping lawyers is a big thing.
This is so weird. Listen to this.
What?
So I just found an article. 4 attorneys lose license, 17 more suspended or reprimanded. Boutros was sentenced to 30 months of confinement in the Federal Bureau of Prisons in order to pay restitution in the amount of $2.1 million. This is another attorney named Boutros, but this one went to jail. I know, right?
And had to pay a lot of money.
But her name was Tricia Steele Boutros, and she pleaded guilty to bank fraud. I don't think she was a prosecutor. So these are just attorneys that were prosecuted for things. Like you said, money. Money is what gets them. Bank fraud. Proving Jeff right, one Google search at a time.
Now, because that's for any lawyer gets the printed version of their state bar magazine or newsletter or whatever. The first thing you do is go to the disciplinary section to see who got disciplined for what. And it's always commingling funds. It's always taking money.
Frank Powell of Spain, this is a Texas attorney. He failed to abide by his client's decisions concerning the objectives and general methods of representation and knowingly used confidential information of his former client to her disadvantage after the representation was concluded without her consent.
That's a bad thing.
That's a bad thing. But that, I know a lot of stories where attorneys have done that and haven't faced 1 second of an investigation. So that's kind of unusual.
Well, we do have something unusual as well. We have a super chat. It's an unusual day for super chat. Oh, cool. Looks like something's happening in the courtroom. Torin3, who's been a member for 1 month, says silk for your braid will arrive today. I'll have the hopefully final design for you before the F at Friday stream starting by Tuesday. Can't wait. Okay, I've got it. I'll send you something in the morning because I had an idea today. By the way, Torin3 has a great channel where he does traditional Japanese braiding. I mean, it's fascinating to watch. Check out his channel if that's something you want to see. Nicholas Starov's Trial Watch. Who is going to investigate the prosecutors, the cops they helped get away with misconduct? Exactly.
Yep.
Or the one, if it's not them, then it's the ones that shelved the initial investigation so it couldn't be used against the guy in a trial.
Yep. There you go.
And Xanothium 15. Judge Borowski, the defendant has a right to a speedy trial, speedier than Aaron Rodgers' first start as a Jet. Case dismissed. By the way, I hope you didn't eat the lunch today. Thank you so much for that super chat. KT, who's been a member for 9 months, says, look up the Oklahoma judge in trouble for texting during trial. Well, gee, Judge, are we bothering you? Are we cutting into your schedule, Judge? All right, let's go hear what's happening. Judge Morticia.
Can we talk about that weird attorney for Melly with the black hair? What is the deal? Look at her. She's brushing. She's literally brushing her hair in court. Is that normal? This is not a normal person.
I was literally in the middle of saying at least lawyer Morticia Adams is in court when you said that.
What is her deal? Has anyone looked her up? She has more Botox. She's like a lawyer.
She's a lawyer. She's had a couple of arrests for domestic assault.
you
That's one of the things we were
serious?
gonna. Yeah, it's one of the things we'll probably get to if there's a long break. We'll watch the 15-minute body cam footage of her arrest for smacking her boyfriend around.
She is
But
bizarre.
it was never prosecuted. So
Oh my gosh. That does not surprise me. She's very creepy. And then she had that weird notebook, her evil plans or whatever.
the evil plans and stuff notebook.
Oh my God.
But yeah, people like her because she's thick. Baby got back.
What? Her face looks like a like Janice the Muppet.
That's why I had Janice the Muppet picture on my StreamYard overlays. I couldn't remember why I had that.
Yeah, she
Thank
does.
you for reminding me. I saw that today and went, huh, why do I have that?
She looks like Janice, as all the women do who get all those fillers. Look, ladies, public service announcement. Those fillers are totally useless. They will make you look crazy. Don't get fillers, just get a facelift. Facelifts work. Fillers make you look crazy like a Muppet.
And speaking of the body cam footage, Agony Goose asked, how many people does she suplex in the video?
Oh my God.
That's good. I like that. She should be combing her hair in the bathroom, not the courtroom.
Yeah, why is she's got a brush in her hair, in her hand? Although we always do criticize the women in court for not brushing their hair. Although I
see, Megan, nothing is right. You're just not happy with anything, are you? Oh, she didn't brush her hair. Oh, she's brushing her hair. What is it with you, Megan? Come on.
It's true. But I mean, there's a time and a place. I don't think you should break out the brush in the courtroom. I think you go to the bathroom for that.
Well, I am naturally pretty, so none of those for me. And that is her name, Raven Liberty.
I'm gonna need an eye lift. I've got these eyelids growing over my eyes. I mean, it's gonna be like an actual medical problem at some point where I'm not gonna be able to see unless I get them taken off my eyes.
Oh, you'll be like Strawberry and Yoda.
Yeah. Yes, it's a genetic thing. It's a genetic thing with our eyes in my family. I have my dad's eyes, and now he's 80, and his are like he needs it really bad,
and he really wants them back.
He needs
waka.
He needs to get it done, but he won't because he thinks.
Ooh,
that's weird.
there's Officer Manley back there. Some eye candy for you ladies.
Ooh, yeah. I
big
think.
Boy. Legal Vices, you'd like her if she was wearing an 18 Australian foot. No, I wouldn't. She's scary. I hate it when people's eyelids go over their eyes. I get annoyed every few seconds. Blink, blink. Legal Vices, apparently the Oklahoma judge was texting her bailiff during trial as if she was on a Ricada trial stream, making fun of attorneys, calling witnesses liars, fawning over a cap, etc. Well, that's not something you want to have happen.
What Oklahoma judge? What is this?
The one they were just talking about a minute ago. Steve Godney says, on laid back news at noon, got to take a shower. See ya, guys.
Bye, Steve.
All right, and before we get going here again, we've got 719 people waiting for this thing to get underway and only 361 likes. Literally half of you haven't done your job. Everybody get down and hit that like button while we're waiting. Come on. We got plenty of time. Just hit that like button. We should be up to 700 likes right now. But let's do that. So YouTube puts us out on a little algorithm-y thing. So they like the number 600. 600 seems to be about where they start notifying you that, hey, people are watching something interesting. Let's see what they're watching. And they start recommending us on the front page and whatnot. So please, just do me that favor. And if you haven't subscribed, please do me the honor of subscribing to the channel. Let's get our numbers up. We are covering, as we did with the first trial, gavel to gavel, Melly coverage, and all the important things in between. So I think we'd love to have your subscription here. We have Megan Fox, writer, journalist, and restaurateur. Ish.
Yeah, my schedule is so much lighter now because the season is pretty much over. And so now I'm barely working and it sucks. Normally I would be working on a day like today because it's a Friday, but I'm not even on the schedule this weekend. So I guess I'm streaming.
Yay. Well, Thank you for deigning to grace us with your presence down here in the slums of YouTube.
Shut up. I begged to be here today. It's like, please let me watch this with you. I can't believe they're an hour and a half behind. I mean, what is this timeline they're on? What is
Court
this?
time.
Court time is terrible. When you say 9 a.m., I expect you to be there at 9 a.m., damn it. It is now 10:30.
Erza says her own husband forgets to like I forget to like. I never like other creators' streams because you're too busy watching it.
True.
And like, honest to God, I harp on it quite a bit. And the only time I do it is when someone says, "Don't forget to hit the like." I'm like, "Oh yeah, man."
Yeah,
duh.
me too. I forget every single time until the creator says, "Please hit the like," and then I'm like, "Oh yeah, I got to go do that."
Sorry, but we do have a like and subscribe poll up. This is just our little daily reminder or stupid lame poll that we do. Today is actually kind of an interesting one. I mean, it's actually topic oriented. So hit the like button, hit the subscribe button, take our little votey vote here. Booting the prosecutor. That was the right thing to do, the wrong thing to do, or all prosecutors should be booted off this case.
All prosecutors should be booted off this case
Well,
is the obvious right answer.
53% said all prosecutors.
Mhm.
43%. Oh, I spelled right wrong. Damn it. Me, literate law. And how there's 737 people here. People have been watching this for an hour and 27 minutes. And to the best of my knowledge, nobody mentioned that I spelled right wrong.
No, the chat did earlier.
Oh, did they?
Yeah, they were laughing about the spelling mistake in the poll.
Yes, I just now noticed, Raven, because I'm not looking at my own stupid poll. Well, I mean, depends. Never mind.
Not that poll, Jeff.
Phrasing.
So 54% says all prosecutors should be booted, and 42% say the incorrectly spelled right is the right thing to do. Only 4% say it's the wrong thing to do. Well, clearly my spelling of right was the wrong thing. But as I always tell people, I'm like, you're a liar, and you don't even you have all these grammar and spelling. Like, when you pay me $400 an hour, I'll pay attention to what I'm typing. Until then, off you fuck. So, coming up, what are we looking at? It's 11 p.m. here, so 10 and a half hours from now, we'll be starting my F It Friday stream, where we have a large number of panelists that come here, and we're going to kind of hang out. It's an open policy thing. It's just an open chat. We got about 24 people that have said they will or may be here. And for those of you that know, some of you might know these people. We have Aussie Overlord, Hayden, Steph the Alter Nerd, that Star Wars girl, Anna Chrissy Mayer, Jasmine Jafar, Lauren De Laguna, Lila Hart, Ari Jacob, Nina Infinity, Talk with Sally, AV to the Seventh Power, one of the lead attorney's sidekicks. Oh, this is my lead attorney impression. Pretty good, huh? AV to the Seventh Power, Chandler Remington, Megan Fox, Flux, Lady Law 579, Potentially Criminal Sean, Radix, Verum, Christina, Waifu Kron, Jess, Meme Copium, MG Law, Steve Gosney, Runkle of the Bailey, Nick Ricada, and Nicholas Starov, Trial Watch. That's the list we have so far. So you join us for that. It starts about 10 and a half hours from now. Bring all of your super chat monies because it's $100 for shots. It's just a pure, unadulterated, super fun griftathon. Let's see how much money you can throw at me, how drunk I get, and how long it takes for my liver to shut down. Until then, we're stuck here with this trial. If they'd ever get to court,
ever get started. I mean, I'm starting to.
Dang it.
I mean, what are they doing? Are they doing last minute negotiations? Are they in the in chambers?
No.
Like, what is happening?
They're all wandering around the courtroom, probably waiting for something to happen. Excited Utterance, welcome to the Clean and Sober crew. Excited Utterance is the newest member. Cool. Great to have you here, Excited Utterance. As always, awesome to see you. Lux, who is Jasmine Jafar? According to her biography, she's a former lawyer who is now a model. So we have a long list of hotties lined up, so don't miss it. The expert, MG Law, don't play with the tip. Chad is killing me today, says KT. The community largely is women in viewers and content. Well, see, this is a very exceptional Effort Friday we have lined up. Normally, it's just a big, giant sausage fest. But it's like full of super hotties this month. So, hey, good for me. I'm not complaining. I like women's. And a lot of the women we have like women too. So, hey, win-win for everybody. Oh, the courtroom camera is moving. And it's YNW Melly is in. Let's unmute us here.
All right, here we go.
Avi is awesome, and she's gorgeous. She will be here. Yes, feminine now. That's what I meant. Excited Utterance arrived just in time. Well, they were waiting for you. It's all your fault. It took an hour and 31 minutes for this to start, Excited Utterance. They're like, God, where is she? And I finally show up so they can get on with it. Lost in Law. Hey, how you doing, Lost in Law? Been a minute. Lawyers cannot spell, use grammar, do math, argue, or advocate. The fuck do we pay them for? Well, you'll find out once you pass the magic bar exam, won't you? You only do those things when they're paying you money to do them. And in the case of math, that's why you have secretaries. At least that's why I have secretaries. I have a story that says women's a sandwich is just my favorite. Cheers. How long till Fuck It Friday? About 10 and a half hours. That's how long, Bella Stella. So now's the time to go clean out your bank account. Griftathon. Does Flux contribute to the Sausage Fest? No, we enjoy the same things. So she very much is helpful and supports me in my decisions and things. David S. says, ugh, the bar. I want those 3 months of my life back. Well, this and Effort Friday is the reason I'm not in a bar right now as we speak. My blood alcohol content is dangerously low at the moment. I'm saving myself for Effort Friday. Oh, this is great. I just got one of these mandatory reboot things. Mandatory update reboots of the computer. So I wonder how if I forget to extend it another 15 minutes, it's just going to shut me down. So I'll be back. If I just suddenly disappear, I'm updating my system and I'll be back whenever it takes. Because now I've got to click this extend every 15 minutes. Great.
Don't worry. I can take over if that happens for a few minutes.
Also, Lincoln Kane will be there as well. I forgot about that.
Fabulous.
It'll only be 9 o'clock in the morning in Australia, so he can't be that drunk.
Uh-huh.
Okay, so apparently we're waiting on the prosecution because everybody.
Yeah, they're not going to show up.
Side is here.
I'm telling you, this is we're so late because the prosecution isn't going to show up. They're playing games again. They can't find who they need to find. Well, I was in court this morning. I had another engagement. I couldn't be here for the biggest event of our lives that is televised, and we're being raked over the coals.
Yeah, she's fist bumping Nelly. It's 1 a.m. in Australia. Yes, it is.
If you reboot now, we probably won't miss anything. You should probably just do it.
Yeah, we'll see how it goes. Well, it'll cut the stream, won't it? I say
Yeah.
won't take me off. It'll just cut the
unless
stream.
It will. Yeah.
Yeah. Melly. All right. False alarm. We thought we were starting because they brought the defendant in.
Apparently not.
Hamsters. Otto says hamsters for some reason. I don't even want to scroll up to find out why someone would randomly say hamsters. But okay. If the state doesn't show up, the judge should dismiss the case. Well, they'll do exactly what he did last time. Get them on the phone. Get them in here. But I mean, for the actual, for them actually not to show up would be extraordinarily bad. Excited.
Don't put
the
it past
stream
them.
will keep going. The stream will keep going, but the YouTube will shut down because the YouTube is on my computer.
Yeah.
So it'll just be Megan staring at y'all.
That's right. It'll just be me.
That's the last thing I want. This can end in a dismissal of all charges. That's what the defense is asking for, Flux, and that's what they're hearing today. That's what they're supposed to be arguing if they argue it. She is a big woman. She's even got like fat on the back of her knees. She's just a big, big woman.
What firm does she work for?
She works for her own firm, I think.
I think
she
seems really bizarre.
She seems to be kind of his handler.
What kind of
his
cases?
Calming influence.
What kind of cases do you think that she does? Or maybe she's like a Hollywood attorney, like a fixer or something.
In the first trial, she did all of the questioning about electronic things.
She is a strange character.
Yes, she is. Well, she is really tall. She's a large, large woman.
I don't think it really helps him, though, to hire someone who looks like a devil-worshipping, coven member.
That has a notebook called Evil Plans and stuff.
Yeah, that it doesn't really help your case when you're trying to tell people you're innocent of murder. Maybe you shouldn't have Elvira as your counsel.
Wait. You apologize to Elvira right now.
I know, I'm sorry.
Now.
She's nowhere near the level of attractiveness. But she's got the vibe.
Nicholas says, I liked her in WWE. Reflex says, I noticed her legs too, but I was eating. No.
That face. Oh. That face.
Yikes. She's got at least two domestic altercations, both of which ended up with her being charged. So be careful. Be careful, Megan.
Of course it did. She's scary.
This Elvira is still fucking hot in her 70s. Yes, she is.
Is she really?
Yeah.
I haven't seen her lately.
She's gorgeous.
I'll have to Google her.
Oh, that's right, Flux. We kept calling her Ludo. Ludo from Labyrinth. Smell bad. Ludo's lawyer. Melly friend?
Oh, yeah. Yes. She's still really pretty, isn't she?
Oh, she is. She's what, like 76, something like that?
Wow. She looks great. And she doesn't look like she's had a shit ton of plastic surgery. Good for her.
Just kind of a nose and boob job, I think.
Yeah, she may have had a facelift or like a neck lift. That looks normal. It doesn't look like she doesn't have a face full of fillers, and those fillers are so bad. Stay away from the Botox and the fillers. They make everybody look the same, just like that weirdo in the courtroom.
We have just hit 800 concurrent viewers and 569 likes. Get down there and smash that like button. There's no reason we should not be at 700 likes right now. Just let's get it done. We got 11 new members as well. Thanks to everybody joining. Okay, so now everybody's there except for the judge. I wonder if we boost this up if we can hear what they're saying.
They're probably talking about Pelotons or some bullshit.
Wow, I moved up the wrong window and you just screamed in my ear accidentally.
I'm sorry.
No, that was just me. All right, listen. I did hear him asking, so who's the new prosecutor going to be? She is the biggest one in the room. All right, now somebody needs to tell me here. I don't know how it got to this situation, but somebody told me last time how to change the opacity of the closed captioning. I can't remember what the command is.
Don't look at me. I don't know any of this crap. I'm bad at all the tech stuff, obviously.
Press O, I think. No, we don't need I think. So we need definite answers. Press O and my computer dies. That would be fun.
Bradley, she won't be there today, right? Because she's been taken off. Will Bradley be here today, Jeff?
No, she's no longer part of this.
That's too bad.
Right,
I wanted to hear the judge yell at her. We're not going to get that. Sucks. See, that should be part of the punishment. Part of the punishment should be a public dressing down by the judge. And they avoided that by the judge ruling on the motion, not live in a courtroom. And so she just gets to quietly disappear. I'm not for it.
There we go. We fixed the caption. Do you want a white background or
Oh my God, who cares? Why do you care about this?
Because the people with hearing impairments care.
Yeah,
so
but
they can read the closed captions more clearly.
But the closed captions are always so terrible. They're like, yes, I submitted the nudist on Friday. Like you can't even understand what the captions are saying. They're so bad.
Because we have to have it. They don't let us have a let's go with the yellow for the font color, because yellow is the easiest font color to see. Okay. The bodyguard guy's coming in. Oh, he's not bringing through it. Font color, white, yellow. Here we go. Font size, 100% good. There we are. We are all squared away with our fonts. Just waiting for something to happen. How about the colorblind? Yes, that's also why we don't do red and green fonts, because colorblind. Yellow snow, Nanook, Nanook, no. Watch out where the Huskies go. Don't you eat that yellow snow. Great lyrics. Thank you, Frank Zappa. Rest in peace. I already got up to 510 likes, or still like 100. Let's move it. All right. White with black outline can be read on anything, as can yellow on a black background, which is what we decided with. All right. Let's get ready to rumble.
Finally.
Finally.
State forward. He's present along with his counsel and the assistant state attorney. Do you want to state your appearances?
Daniel Aronson with behalf of Mr. Devins. Stu Adelstein also present. Raven Liberty.
Okay, Adelstein's there.
Mr. Devins is present.
Morning.
Good morning,
Your Honor.
Good morning, Your Honor. Stephen Klinger and Paul Blum on behalf of the State Bar.
All right, so we all set with proceed. We have a motion to dismiss, I think.
Yeah, that's the last motion I believe we have pending as far as the sets that we had for this week. Your Honor, I think we have an agreement with the state, instead of calling this Boutros again and calling this Bradley again, with the court's agreement, we have agreed that we will stipulate to their testimony that was taken during the motion to reach.
Oh, I want to watch him testify again so I can crucify Bradley again.
Hearing to a motion to dismiss. This would be identical testimony. It wouldn't be anything different.
Can you boost them anymore?
So it's agreed. That's fine. So regarding the deposition of both Ms. Boutros, it's the trial testimony, the hearing testimony, not the.
How is that?
Right, the hearing testimony.
A little better.
And Ms. Bradley. And do you have copies of the order transcripts?
I do not.
I mean, I heard the testimony. I have notes, but I didn't know if you were ordering a transcript.
I'm sure at some time, well, we have not. I did not know until this morning we had this stipulation or.
Well, if there is a stipulation that it's done, is it going to be ordered?
We'll order.
Okay, so then you can.
Okay, we're at 400% now.
Thank you.
Can we hear okay? Or do we still need to boost it up to 600?
Said with that stipulation.
This is a double murder trial. Motion to dismiss.
State Attorney Pryor, Assistant State Attorney Falk, and Assistant State Attorney Hillary. You have entered your order. We respect your order. We cannot call that. So therefore, we don't have any more witnesses. But I would like to proffer what I believe we would get if, in fact.
All right, we're up to 600%. This is it.
Go ahead.
Your Honor, what we believe we would find that if we call them as witnesses is that Ms. Boutros, as she testified to, immediately upon hearing what Detective Moretti solicited to Deputy Gorel, she informed her supervisor, Mr. Killoran. We believe with the testimony would be that Mr. Killoran then went and he talked to the supervisors in the office. My understanding is we will find out that in fact there was a meeting with Ms.
Well, if it's still too low now, there's nothing I can do about it. This is as loud as it's going to go.
At times it was just the state attorney.
Hang on, just a second.
Jeff, you're so loud.
I don't know which.
You're louder.
Together.
Blowing my ears out.
Hang on.
I do know that they were talked to in conjunction with each other and separate. We believe that we would have testimony that they were instructing Miss Bradley to file the Brady notice. And this goes back as early as basically in October, November, whenever it was, of 2022. The testimony will show that after they did that, pretty much everybody put their head in the sand. They did not check into things. She went
How is
through
that?
the whole
I
trial.
cannot do anything
Sat
else.
through the trial.
Better.
Nothing was mentioned about Brady. We find it hard to believe that nobody would have asked her, even after the hung jury, well, how did you handle that Brady issue? What happened with the impeachment of Moretti? Those are things that after a trial are just talked about. But regardless of, we don't know what was talked about. That's what we would try to find out about. We know that even after the hung jury, Brady, as far as what we're talking about, this impeachment material was not provided. And it continued not to be provided until Ms. Boutros took it upon herself to allow the world to know that the state was hiding evidence. Anyhow, you have the three different four Brady notices. You have three different ones as far as the impeachment material goes. And if you notice, one is signed by Ms. Bradley and one by Mr. Killoran. Why we believe the testimony would be that Ms. Bradley refused to sign the Brady notice that was prepared by the supervisors in the office, and she refused to sign it. In fact, it was handed to her by her secretary, and she said, "I'm not signing this." And that's why Mr. Killoran from Public Corruptions had to sign that Brady notice.
She refused to sign her own Brady notice?
Basically eat it. Then she turned around and she files another subsequent Brady notice. What happens to Ms. Bradley during this entire time? Absolutely nothing from what we know. What we do know is even when we filed a motion to recuse her because of this, the state vehemently has
Judge
been
is rubbing
opposing
his
that.
head already.
So they didn't sanction her.
Everything you're saying.
They buried their heads in the sand.
Robert is too
As far
loud.
as what she was doing, they allowed her to do what she was doing. After it comes to their attention, after the mistrial, that she's committed a Brady violation, and they tell her to basically get the Brady notice out. She refuses. When they send out one, she changes it and says that's inaccurate, and they do nothing to her except fight to keep her on this case. That's institutional. Then we're here in front of this court, and I said to Ms. Bradley, can we stipulate to the testimony of Ms. Boutros when it comes to the motions to suppress? Or do I have to bring her back the 13, 17 times? And she says, you got to bring her back for each one. That's retaliation. That's retaliation because she had the courage to tell the truth. And that goes to the office of the state
Wow.
attorneys. You put it all together. There was a mistrial. They hid Brady material. Making Mr. Demons go through another trial is a violation of double jeopardy. Jeopardy should have attached because of what occurred. Now, I filed a motion, and I don't want to go through everything in that motion again. I'd like the court to accept that motion as what I would also and add it to my argument instead of just being redundant. I believe it automatically is, but I would just like to state that. Anyhow, the bottom line of it is, I've cited to the court Glosson versus State and some other cases. I did not cite to the court one case of this fact situation. Again, I don't know if a case of this fact situation even exists, but Glosson tells us that the actions of the state attorney's office can be such a violation of due process that due process demands a dismissal and not a retrial. And that is what we're saying here to this court, that it's a the due process.
He's going strong. I like him.
Mr. Demons go through court, a whole trial where he's facing the death penalty, while the state is holding on to that Brady material. And then even afterwards, it doesn't get revealed until somebody else has the courage to come forward, is institutional. And if you, the case I've cited of Izquierdo, again, not on point. That case deals with the fact that a state attorney apparently had been sanctioned by his office or disciplined by his office before for comments that he made. And then that trial just goes overboard. The case is reversed. It goes back all the way up to the Supreme Court the second time. And what they basically said is that the case can be dismissed. Izquierdo did not put on enough evidence at the trial level when it was remanded. He relied on the original appellate decision thinking that he was a winner. So the bottom line of it is that if you have institutional, I'm not going to say corruption, malfeasance, and it's part of that institution, then this court has the power to dismiss. And under these facts, we ask the court to exercise that power because double jeopardy will be violated if you don't. Okay. Now, Your Honor, I have here statute 838.022. It is a crime in the state of Florida. It is unlawful for a public servant or public contractor to knowingly and intentionally obtain a benefit for any person or to cause unlawful harm to another by A, falsifying or causing another person to falsify any official record or official document.
He's going back to they committed a felony argument.
Already was violating this statute.
But we're going to object only the outside the four corners of the motion. Now I think the argument is not appear in this motion.
Thank you.
That guy can never be heard. What is wrong with him?
C of the same statute, obstructing, delaying, or preventing the communication of information relating to the commission of a felony that directly involves or affects the government entity served by the public servant or public contractor. The state attorney's office itself violated C, obstructing, delaying, or preventing the communication of information relating to the commission of a felony. And that's the felony we're talking about, is what you already did. That directly involves or affects the government entity, if they're the government entity, by the public servant or public contractor. So, Your Honor, what we're saying also is not only was there bad behavior, but quite candidly, the state attorney's office, the way they handle this, are party to criminal activity and committed criminal activity. Based upon that,
See, they did that in the first hearing as well. The hearing last week, they accused the prosecutor of committing a felony and the police officer of committing a felony and or robbery.
If you look at the whole picture, and this whole picture demands that this court exercise its jurisdiction, determine that it was institutional, and dismiss the charges. Thank you.
Thank you. Yes.
That's a rehashing of the motion we read earlier.
Well, I would like to say that counsel was giving a proffer to the court, and then that proffer sort of merged into the case law, and counsel's reasoning. So, but that was just a proffer. They don't have that evidence in this hearing, and therefore this court has everything he was arguing about, the institutional problems in the state attorney's office, and there was no charge filed, that hiding evidence, all of that is not on the record for the argument for this motion to dismiss. None of that. They only have what was said in the two testimony from Bradley and from Ms. Boudreaux. That testimony indicated that the office of the state attorney told them to tell.
Yeah, because you wouldn't let the other witnesses show up.
Let Boudreaux testify, let talk to the defense, and there was no indication of any hiding of evidence. There was no indication of institutional obstruction of justice.
Oh, I think there was, pal, and you know it.
Evidence at all that they, the prosecutors were told by administration to do something illegal or were told to hide anything. That was all a proffer he gave you, and then he uses the proffer to say, okay, well, under the law, dismiss the case. There's nothing here that would allow the court to dismiss the case or dismiss the indictment. The normal remedy for a Brady violation is a new trial. Of course, here that's not an issue because the defendant is getting a new trial, and they are aware of the statements that were made by Detective Moretti, and therefore there's no prejudice.
I think that's the argument there that wins it for the prosecution. They're not on trial. They're getting a retrial. They know all of this going into the new trial.
They should have waited. They should have waited till the trial started.
Back to talking about Brady evidence and materiality in this motion. So again, I'm not trying to underline what the court wrote. I'm just making a record on the part of the state, which kind of is mentioned in the court's order yesterday on granting the recusal and so and as the court stated, the state has been arguing that this is a collateral issue. At least the investigations that Ms. Boudreaux and Detective Moretti were conducting when they seized the cell phone from Ms. King, and he allegedly made this statement asking the Deputy Gorell to say that he was there at the time of the seizure. We still maintain that it's a collateral issue. To a degree, I think maybe the court is at a slight disadvantage because the court has only heard maybe people talking about that investigation and doesn't really know the substance of it. And the state would be more than glad to offer.
I'm going to object. I think we're getting into a rehearing on your ruling, not on.
Excuse me. This is counsel's opportunity to respond to the argument. Let them respond to it. But again, both state and defense could call any witnesses they want at the hearing. Detective Moretti wasn't a witness who was called by anybody. So I really don't know what Detective Moretti would say if called to the stand and testify. All right. So you proceed with your argument.
The state would suggest that if the court would like, the court could do a in-camera inspection of the investigation itself. And that would allow the court to look over the investigation, to be aware of all the factors when looking at the issue of whether or not that's a collateral investigation or not. So the state is offering to the court to provide that investigation to the court for an in-camera inspection to help the court.
What investigation are you talking about? The Miramar?
The investigation into the tampering that ASA Ms. Boudreaux and Detective Moretti were in the room that day and taking the statement from Ms. King.
Who was doing this investigation?
The investigation was being handled by the state attorney's office and by Ms. Boudreaux, who was handling the investigation along with Detective Moretti.
Not the Miramar investigation. I was told, and I thought it came up in the hearing that there was some type of internal affairs investigation that was done by the city of Miramar.
It was later on, yes, sir, a year later.
I just wanted to clarify what investigation you were talking about.
I'm sorry. This was this investigation that Ms. Boudreaux and was conducting at that time into witness tampering. then that would just be with.
They will definitely use this to impeach Detective Moretti when he's called to the stand again.
And that's what the statement was supposedly.
They're going to call the prosecutor in the last case as a witness.
Thank you. Go ahead.
So again, and now I am going to reiterate the state's arguments.
I have to object. He's even stating, he's reiterating the arguments they had on other motions.
Thank you.
The jury's not here today. They were talking about having Boutros come in again today. The jury's not here. It's just between the counsel and the judge.
It's hard because in this motion, as the defense says at the very end, and that's the third prong of Brady. And the third prong of Brady is materiality. And to start, I can't answer the motion without talking about materiality, whether the statement was material. It has to be material to the case, right? So
it's not material to the case that the lead detective would lie.
Under that, it's material to the case. We're looking to determine whether a Brady violation occurred. So when you start with that, the statement must be, evidence, the statement must be relevant, right? It must apply to a matter of issue and not in materials. And the state's argument has been that this is an impermissible state impeachment evidence based on a collateral issue. That is why we're going to do camera inspection. That particular investigation is not part of the homicide in any way, shape, or form the facts of the homicide. So, again, not collateral would be the first argument. The second argument being that when you get
he's making the best arguments he can. He doesn't have a lot to work with.
I think the judge is going to let him
bring in witnesses, right, that are testifying to something that they weren't a party to. Ms. Brennan wasn't there. So for a testimony, she was coming in testifying for collateral issue wherein she was not even a witness to the initial incident. So it's
the judge's face right now.
It's not great in the sense that
I don't think he's going to dismiss the case either.
No.
If it would have been during the last trial or after jury selection started in the retrial, I think he would have dismissed it with prejudice. But because they're between trials, the remedy is a new trial, which they're getting.
That is what they look at. They say, well, you have to look at the evidence. That evidence is going to make a difference in the outcome. And in this case, when you go to the first argument is collateral evidence, and then you say you're going to have the witnesses come in and they're going to be giving impeachment. Well, if the detective maintains the statement and they want to call Ms. Boutros to counter that, that is not permissible in the sense that now they're commenting or trying to impeach the witness, the detective, with evidence that of a prior bad act. And you cannot do that. You can only impeach with character. You're going to say character evidence, it's not truthful, you're going to bring in witnesses.
The lead prosecutor was removed from the case earlier today. They have a few days to find a new prosecutor.
Prior bad act. Now, I'm aware of the court in its motion, in its order on accusing Ms. Bradley, argues that it was material, that the execution of such material falls within the exceptions to the collateral impeachment. So the court basically was saying there's an exception, and where there's any doubt that a witness might have bias or motive. But again, I understand that's the exception for the cites, but in this instance, there's no possible bias in the sense that nothing's pending against it, that there's no charges pending against him, there's no reason for him to come in to lie. So it becomes a little difficult when you're saying, okay, there's an exception to the collateral impeachment rule, but even those exceptions, bias or motive to exaggerate, and I'm quoting from your order, or even fabricate his or her testimony, the defendant has a right to explore that bias or motive before the jury, but there's no indication that there was any bias or any motive. There's no charges against him. There's nothing. And you don't know, like you said, you haven't heard from him. You don't even know what his response would be, but he was called and asked whether he said the statement. And that even gets into another issue. If he says, yes, I said it. Well, then what? It's, of course, it's up to the defense at that point. If he says, yes, I said it, why in the world if they want to call anybody, they got what they wanted? I mean, you better call, you can't call it Boutros, because she's going to give consistent testimony then. And for them to call Ms. Bradley at that point to what? To question what they wanted. They got, the officer gave them what they wanted. He made that statement about asking the other officer to lie. That doesn't make any sense. If he comes in and he maintains, hey, I didn't take it, I never said it. Well, at that point, they're going to bring Ms. Boutros in and say the opposite. But to bring Ms. Bradley in, just say it would be a consistent statement. But she is going to say, be consistent with his testimony. So we have those issues, but then I agree that, there is an exception that the court cites in its order yesterday, but I don't see how they're going to be able to discredit the witness through bias or lack of competency when there's nothing pending against the officer. There's no reason for him to come in and lie. I would say to the court, there's a lot of arguments were made in the state's memorandum of law was filed Monday in support of an order denying the defendant's motion to use the state attorney's office. Those arguments apply here because it would be the same thing. And that's why I apologize to you. I don't mean to be going against your order, but I'm just having to renew those arguments because they apply to both cases in the sense that you're looking at whether or not we're grading it. And so I would ask to adopt the legal reasoning that's found in the state's memorandum of law in support of an order denying defendant's motion to refuse into these motions, the arguments with the state on the motion to dismiss. And again, we offer to the court to take a look at give an in-camera inspection, not a proper in-camera inspection of the investigation itself, to see whether or not the court can make a further determination as to whether that's collateral to the issue, because that's the first step in grading. It's got to be material to this case. And when you have another case, it doesn't fly. The defense has gone a step further, getting a proffer, trying to say it was corruption in the state attorney's office, hiding things. And again, none of that was shown to the court. That's not part of the record. So the court made a reasonable ruling on the motion to quash. They're not testifying. Therefore, they have the testimony of Mr. Cruz, the testimony.
Because they kept out the testimony.
And that certainly doesn't rise to the level of a due process violation. There's been no showing whatsoever of an institutional issue with the state attorney's office itself. The court made such a proffer, for the most part, never said there was even prosecutorial misconduct. So to get to a due process violation that would require dismissal of the indictment, they don't have the evidence for that. And therefore the court must dismiss or deny.
Because we kept the evidence from them by telling the witnesses not to show up at court.
To the extent that you were going to revisit the Brady issue, I was not prepared to argue that today. I didn't think that's what was on for today. And if you are going to be reconsidering that issue, I certainly like the opportunity to address it with the case law that I have and the files that I have and whatnot. We think your order as to that issue is exactly on target, and we do not have a problem with it. I do want to point out just one thing that was said, and that is that Detective Moretti getting on the witness stand, and if he acknowledges that he said those things, we can't impeach. So the state is saying that Detective Moretti would get on the witness stand and confess to a third-degree felony and probably some misdemeanors. And that's part of their argument. You know what? If it turns out that way, that he's willing to confess to a crime on the witness stand, we'll live with it.
We'll deal with it.
Other than that, I stand by
That's
my
not a
word.
bad day.
Thank you. So, council, also for ruling, take under advisement, state asked and offered an in-camera inspection of the Boutros State Attorney investigation. Any objection to that?
Your Honor, yes, because we know that a lot of the stuff was verbal comments that were made. And I don't know how the court gets those verbal comments that were made to each other and whatnot. So I think you're only getting half the picture.
Make them testify.
As far as the transcripts of both Ms. Bradley, the testimony, not trial testimony they give, you need a minute? She's already no. Take your time. You need a minute?
This
Oh, she's up on her haunches.
This in-camera, look over of the investigation is garbage too. That's nuts.
Just 1 second, all right?
That's just a way to keep it out of the cameras, off of TV, and let the judge do what the judge does for the state behind closed doors.
Your Honor, I think it's important to just note the sequence of events as far as Detective Moretti. Detective Moretti's statement occurred after the seizing of the phone from Ms. King, after the search warrant and whatnot. It's all part and parcel in this case, as the court has found. Bottom line of it, Your Honor, is we just stand by our motion.
Thank you. Ms. Liberty wanted to chime in. I was asking you about the transcript because you're saying that you're relying on the evidence from the trial hearing testimony from both Ms. Boutros and Ms. Bradley. And I was just inquiring as to when you anticipate having that. Ms. Liberty was chiming in to offer me a suggestion.
So we tried to order the trial transcript. We were quoted $5,000 for the cost of that hearing transcript. I said $5,000 is a little expensive because we're still having them work overtime getting us the transcripts from the last trial at this point. So we don't have the transcripts. I think even if I was to order it on a regular order, not rush, I'm looking at a month.
Thank you. I don't know about that. I don't know how long it takes to be candid with you. I don't keep track of that, but it's, I don't know that you need this overnight or anything. I mean,
No.
we have 30 plus motions that resolve.
And I think you just need it for the record right now.
Right, I took my own notes and stuff like that.
Yeah, so we'll just order it normal, then this will supplement the file.
Is that all right?
That's fine. So,
So let me switch topics. Who's going to handle this?
We just received your order yesterday, but they're working on it nonstop. So we'll have
So
somebody.
now they have to decide who the next prosecutor is going to be.
I don't take it as any disrespect or anything like that. Or you anticipate filing something with the higher court to challenge the ruling or not? Or is that something still in discussion or debate? I'm trying to get an idea of where we're going and what the schedule is going to be like.
There is still some discussion, but as of right now, no, we have not.
So you're still in the process of trying to find out who the attorney is going to handle the case.
That's correct. And we're close to a decision, but we don't have any stuff we need for the moment on that issue.
Always welcome, counsel. The issue I have going forward is we started talking about hearings starting on Monday with some of these motions. There's in excess of 30, fair enough, in excess of 30 motions that are outstanding. I know there's
30 motions are
that
outstanding. Jeebus.
and I need to get them scheduled because we're on a time crunch. So when and where, and I believe I wasn't present when it happened, but my understanding was Ms. Liberty was trying to find out and get some time for hearings. At least my office was contacted the other day, and they were asking about when we scheduling hearings. I told them we'll talk about it today. I told my secretary to tell Ms. Liberty.
So he's obviously not going to dismiss it because he's already planning the trial.
So we can get on it. Because there's a lot. And I know when Ms. Bradley was here, she was talking about on some of them, there was issues that were, I don't want to say commingled, but their same testimony might be to resolve those issues, and we could take 3 or 4 of them on the same day, something to that effect. I don't know if those discussions, who's having those discussions, and what scheduling has been agreed to at this point.
I'll answer that for you, Your Honor. Ms. Bradley and I have a failure to communicate. As one of my favorite movies always use that phrase. Bottom line of it is that we did not work out any scheduling orders. In fact, we have a disagreement as to what motions can be heard.
And Judge, also,
Excuse me, I'm sorry. I don't understand as to when you say what motions can be heard.
Well, I believe Ms. Bradley would contend that some of the motions are moot because they've been heard before or whatever. And I think she would contend that some of them are not going to be heard because they're not going to be introducing that evidence and whatnot. So I don't know which ones the state thinks are right and which ones aren't. Right now, all the ones we filed, we believe are right until we find out otherwise.
And Judge, I spoke to Ms. Bloom before this hearing started.
Ms. who?
Bloom. Yeah, sorry.
I thought you said blue.
I mumble sometimes, I apologize. So anyway, the state's position is we got to figure out who's going to be handling the case. And as soon as that happens, we'll get with the new prosecutor and try to work out all the logistics. And of course, the side issue is the state listed, 20 new witnesses. 22, I was close, that we have never heard of before that we need to take depots. So we're going to have to try to schedule in between jury selection and everything else in motion practice. That part. So we'll discuss.
Excuse me 1 second. Do you know who these witnesses were?
No, I know there was new witnesses listed, but I cannot tell you the relation to the case.
This has to do with the new allegations.
I believe this has to do, it may, but I also believe it has to do with the new case.
May I respond to that?
Sure. I'm just trying to get an idea.
Sure.
I was preparing a motion regarding these depositions because I've been trying to schedule depositions for about 3 weeks. As of yesterday, I finally just laid out number 1, number 2, number 3 to Ms. Bradley who needs to be deposed. They are not all regarding the new case. Actually, we've seen motions saying nothing about the witness tampering was going to be brought up in the murder case for Mr. Klinger. 2 motions. So we got, I believe, 10 inmates that are testifying about gang activity, which would be after the date of the murder. I don't really think it's relevant, but we have new experts.
Snitches.
I did.
They've got jailhouse snitches.
The experts. I was told she was at the doctor's
Lots of snitches, all the snitches.
Instead, I got your order recusing her.
I wonder what they offered him in exchange for their
offered up my Saturday,
jacked up testimony.
I have 3 of my own motions going specifically to evidence provided in the cell mapping and the pedometer. I have been given a new witness for the pedometer. I'm assuming after I wrote the motion to keep Detective Moretti from testifying, the state added somebody else now to testify about the pedometer. I need to depose them immediately.
Thank you. So, when is this decision going to be made as to the attorneys?
Very, very soon. I'm sure it'll be made by either the end of the day or by Monday.
Well, Monday, we're supposed to start hearings. So assuming we started the hearings on Monday, who's going to be? Is that you?
Right. Well, yeah, it may well be, but I can't really answer as to who it would be. And I also want to, counsel said that in my motion, anything in my motion referred to the investigation and asked you to look at it.
You know, your motions were really clear that none of the evidence from the witness tampering case would be used in the murder case. You wrote it twice in 2 different motions.
Your Honor, if I may, let's conclude on behalf of the state. The state's motions and memorandums are very clear. This is regarding the witness tampering investigation that Ms. Boutros was conducting. This has nothing to do with the subsequent arrests that were made. And as Mr. Klinger indicated, this in-camera hearing or in-camera review is forced.
Okay, well, they're talking about other things. I want to get their unhung hero. He said these prosecutors need to be made an example of. Yes, they do. Thank you. Okay, Boutros testified in the previous hearing that she received a draft of the notice and Bradley refused to sign. Yeah, they testified to that here earlier today as well.
It has nothing to do with the pending charges and the new arrest.
Thank you so much for the super chat.
This is the way, I told you I would defer ruling on that issue as well as the motion to dismiss. I'll let you know. We'll conduct an in-camera inspection of what's going on in this inspection, or excuse me, investigation by Ms. Boutros.
So what he means by in camera
my concern, I
is
guess, is
in his own chambers by himself. He's going to review the internal investigation, the internal affairs investigation, and all of these things. And then he's going to decide later.
With his assistant state attorney handling it is the case, but the concern, I guess, is that this is a speed trial where it's an issue. My understanding is that once the speedy time expires, I think it has already, hasn't. No?
No.
We got reached the verdict on the 21st. 21st falls on a Saturday, so on the timing rules, it would be the next Monday, which would be the 23rd.
So you have a better, you've looked at this, so you think it expires when?
The 23rd of this month, October 23rd.
All right, so October 23rd of this month. So
A week from Monday, they must start.
Certain other caveats that have to happen. Council have, they have 30 motions that they filed recently. It's a new defense team, new additions to the defense team. And there's a lot of motions that need to get heard. I understand all of that, but we all are under the gun, so to speak, because there's speedy trial. My understanding from the defense, they've made perfectly clear they're not asking for continuance. They want to have the motions heard and they want to be able to try. That's the way I understand it. So it's really imperative that I know who's handling the case for the state.
I understand, Your Honor. And again, I think,
This is the third time he's pressing to say who is going to be prosecuting this case for the prosecution. Because the prosecutor that's going to be handling the case has to come in next Monday and start arguing the 30 motions.
Another solution for the court, if the court doesn't mind me giving one, and that would be Judge Fine picked a jury this week on a capital case. He had 250 jurors coming in next Wednesday. They were reserved for it, but they got the jury this week. Those jurors are in fact available, so that the court could go ahead, because of the prejudice in the state, in the sense that we now have a federal prosecutor on the case. And this prosecutor has to get ready. And in order not to prejudice the victims' families and the state and the people of the state of Florida, you could bring a panel in on Wednesday, swear them, and have them come back later on, or after the holiday.
No, don't do that.
It's speedy trials, all of these motions could be set, and depositions could all be set within a reasonable time period, and then when the jurors are coming back, without any other issues with speed, and they could be heard, with everybody having a chance to be prepared.
He's trying to get around the speedy trial rule with that
I
suggestion.
agree with anything you said, but that doesn't mean that's the way it's going to happen. It's a distinct possibility, but it's also, assuming that if this defense intends on filing a notice of expiration on, you said 23rd is the date, is that right?
Yes, unless you want me to go to the 21st.
State's going to meet on the 23rd. They would have to file a notice on the 24th.
So if they intend to file their notice on the 24th, I intend to start the trial. And, no disrespect to defense counsel, these motions and depositions are going to be put to the side, so to speak. We're going to go forward on trial. That's what you want. That's what we'll do. If you want to get the motions and the depositions taken care of beforehand, we're going to go on trial Monday through.
So he's not dismissing.
Yeah, pretty much. It's pretty much essentially saying he's not going to dismiss.
You want to say Fridays for whatever type of work you were doing. And I said okay to that unless there's some change.
And thanks to whoever in court coughed directly into the microphone and overrode the microphone settings in the court.
Be going Monday through Thursday, and you can do what you need to do on Friday.
I think our calculation maybe speedy runs earlier than the dates of their.
I think it may be on that Friday.
It might be on the 20th, so.
Yeah, pursuit.
I'll take it, I'll take the 20th. I'll take the 20th, Judge.
I think you're right.
So there may be less time
Great.
in that sense.
Whatever it is, and you'll know and you'll let me know, but the point is, we're up in a time crunch.
And let me ask also for, I appreciate the court at least consider the proposal that I made. And also, I know the court's ruling, and it seems as though that a ruling on Ms. Bradley's price applies to trial, because that's how the defendant's process was to be violated during trial. Is the court ruling that she could not handle the motions, still not handle the motions themselves?
She should be out of the case now.
Judge, the only other thing I wanted to add, Your Honors.
They have to start the trial within 3 months from the date of the previous mistrial.
In camera.
And that ends on the 23rd of this month.
Take it under advisement. So if in fact we do decide to do that, let us know. And we just ask if you find that it's something that we can have and it is discoverable, we'd like a copy as soon as that decision will be made. That's all.
Well, they're telling me
Snivys
it's
has a
something
good
about an ongoing
question.
investigation. It's still pending. So typically, that is not something that will be shared with the defendant. I don't know what it pertains to specifically.
Do you see it, Jeff? So how many trials should a corrupt state actors get to arrive at the conclusion they want? It's a great
Sure.
question.
That's why I'm
How many
asking
tries
this.
do they get?
This began before October of 2022. So if it's still ongoing, you know, if Your Honor notices that there's no activity since October of 22, that maybe there would be more to it than just them categorizing it an ongoing investigation. So that's all I'm suggesting, is that it may be discoverable regardless of how they label it.
Thank you. Anything else?
Maybe still would help the court if the court wanted.
I'll let you know. Again, I don't know if something I want to look at, because if it's an ongoing pending investigation, it's not something I can really share with the defense. I don't like, I never really like doing that with the candidate, so it's not something you can share in open court. I don't know what my feeling is, so let me think about it. But I need to know about the attorney.
That's the fourth time he said, tell me who's prosecuting this.
There's 13 motions to suppress, and I want to get those resolved. I don't know if the witnesses, I assume they're under subpoena for the trial period now, because we're supposed to be starting this week.
Your Honor, the last time you made that comment, Ms. Bradley was here, and she said because jury selection was going to take so long, that the witnesses were not under subpoena.
So,
Ms. Bradley, who's that? Who's that? She's persona non grata now.
I remember what Ms. Bradley said, but if that's the case and there's no witnesses under subpoena, how long would it take the state to get witnesses for this, for these motions?
As soon as we know.
The fifth time he said, get me a prosecutor.
And that is why, again, suggestion of making the jury that fine that would certainly help in the situation, certainly prejudice the state in the sense that for a new prosecutor to take over this, it's a double homicide, we're asking for the death penalty, it's a case.
Whose fault is that?
For a prosecutor to last minute to.
Whose fault is it? There's a new prosecutor at the last moment, you fuckwit.
That's why made the suggestion to the court, but holding the panel next week on Wednesday, swearing them in, asking them to come back, and then letting the prosecution have the time to prepare for such a large case and these complicated motions. And we'll also give the defense time to do their depositions and file whatever motions new motions they can file.
Thank you. Anything else to discuss at this point?
I do have, so since we're doing scheduling, I did have one motion that's not a motion to eliminate. It was basically started off as a motion to compel the each week. My second one to get the self-map evidence. We did get a new expert, which I listed. My new expert went through the documents and then informed me that all the CDRs that the state has been provided are not what comes from a cellular company. They went even further and pointed out that somebody went into the evidence that's supposed to be direct from the mobile company and
No,
the names,
he's been
assigned
replaced.
names to phone numbers. So I would ask that that hearing be held as soon as possible because we do have an huge evidence issue that needs to be resolved immediately.
Thank you. Well, I'm not going to get involved in that until I know who the prosecutor is. I need to know who the prosecutor is.
That's the sixth time he said, I need to know who the prosecutor is.
I'll set a hearing. If you have decisions going to be made, you think today or Monday? Yes. All right. So if I put this on the docket for Tuesday, that work? You'll know who they're, and somebody's going to have an opportunity to discuss. I guess whoever's going to do it is going to discuss with the defense counsel about scheduling these motions and which ones are going to go first and which ones you want to do and which ones need testimony.
Is he even going to rule on the motion to dismiss?
Available and how long they're going to
Or is he just going to ignore it?
There needs to be some
Judge,
discussion regarding that with the defense counsel.
I have the bulk of the motions. I have written that I will be happy to coordinate in any way I can with the new state.
All right, so are we done? Yes?
And Judge Walker, on the record, I do have 4 USBs that were provided by Ms. Bradley to provide feedback, so I just want to put that on the record.
Thank you.
Thank you, Your Honor.
Can I see counsel sidebar, please?
Okay, well, they're at sidebar here. Let's see. Oh, yeah, that's nice.
Oh, ow. Jeez.
That hurt. Okay, so essentially what he's saying here is on this motion to dismiss, he wants to privately review the investigation, the internal affairs investigation, and to consider the transcripts from the previous hearings, and then he will make the decision. So probably over the weekend, he'll do something. But it's clear from what he's saying that he is not inclined to dismiss the entire indictment. So he's going to leave it up to the jury, which is understandable, and that's how I thought it was going to be turning out. But he's also not taking any crap here. He's saying the defendant has not waived his right to a speedy trial, and trial must start. The jury, potential jurors have to be sworn in by 3 months from the date of the mistrial, which is the 23rd of this month. So it's like a week from Monday. Is that when it is?
I don't know.
Yeah, it's a week from Monday. And so what the prosecution, they suggested to get around all of this. Hang on.
I don't know how he gets a fair trial.
Is that it?
I guess.
I guess until we see something happening there. So what the prosecution is suggesting to get around this, you bring all of the 250 or however many the hell potential jurors they have, bring them in on Wednesday, swear them in. So technically the trial has started, and then just sort of dismiss them and say, we'll call you when we're ready to go. And then we can spend lots of time going over all these motions and stuff. And the judge said, nice theory, nice idea, but that doesn't mean it's going to go that way. So the prosecution is trying to do an end run around the speedy trial thing, and I think the defense is going to have anything to do with it. They want this to start,
and
their whole.
I guess. I mean, if I'm on the jury, and they put the former lead prosecutor on the stand, who then blows wide open this scandal that happened, it's over for me. I'm saying not guilty. I don't care. Like it are they going to be able, Jeff, if they call the prosecutor, Bradley, are they going to be able to notify the jury that she was the prosecutor on the last trial and that she was kicked off this case? Is that going to be something that they'll be able to say?
I mean, she's doesn't exist right now. She's, they're not going to say, oh, we've changed prosecutors, but they're gonna. I don't know how they how they do a retrial, how they prosecute without the lead detective there to give testimony, because he was the main witness. He's the main guy.
Wait,
He signed off on all the affidavits.
Are you
So they
saying
put him on the stand.
that they're not going to put him on the stand?
I don't know. I mean, they have to. I don't know how they prosecute if they
But if
don't.
he gets questioned by
That's the
defense,
point. Yeah.
he's going
They're
to
going to call her as a
He's going to
witness.
plead the fifth. The detective is just going to plead the fifth. He's not going to confess to a felony. You heard that. He's not going to confess to
Mhm.
that on the stand. So he's going to just plead the fifth. Then
Yeah,
they'll call
but
the
then you
prosecutor.
bring. Yeah, well,
She'll
then you
lie.
bring. Well, I mean, she's already testified under oath last Friday. As to what
Right, and
happened.
it was a bunch of lies. I think what she said was a bunch of lies. Oh, it was a joke. And we did nothing wrong. And it wasn't even Brady. We decide what's Brady. No. I don't know. I don't see how he gets a fair trial. I don't think they're going to allow the evidence in for the jury to see it. I think this is bullshit. But whatever. He probably did it, so I guess we don't care. I don't know. I care.
You do. I mean, anything that the lead detective says is gonna. I mean, he's gonna get crushed on credibility. I mean, the first thing they're gonna do is they're gonna call in Boutros, and she's gonna
She's a great
spill the beans.
witness.
She's gonna crush his credibility.
Yeah. Yeah.
And you know that he's going to get crushed there.
Well, I'm disappointed. This hearing was a big nothing burger. Gosh darn it. Disappointed. I wanted bench warrants. I wanted more people pulled into the courtroom. And I'm really upset, Jeff. And here's the way I see it. I think the defense really screwed up. They really screwed up by having that the motion heard last week or whenever, when they should have heard the motion to quash first. If they had the judge, to my knowledge, has still not heard the motion to quash. Why?
These are to quash the subpoenas for the other people in the prosecutor's office.
Yeah.
He's heard some of them. Yeah.
Did he hear them?
Well, that's, I mean, those, I assume so, because that's what they were doing last week. They were doing a lot of the motions to quash. And that's why he said that, you know, some of the prosecutors don't need to be called in as witnesses.
So he ruled to quash some of those testimonies?
Apparently.
See, why didn't we get to see that? See, this is a cover-up. This is an institutional problem. If we didn't even get to see the hearing on the motions to quash, that's a problem, because we need to know why the judge decided that Pryor doesn't have to be called and that the other...
Well, we were not allowed to see it. He didn't say you can't see this. You know, anybody can go in the courtroom and see it and watch it.
But it wasn't televised.
A couple of them were.
All right.
But
so we just
you know,
didn't watch
the other ones weren't. It's, you know, Law and Crime didn't want to put them up and whatnot. They covered some of them. They were like 12, these short 10, 12-minute hearings and whatnot.
I wonder why. So did you watch any of them? Do you know what his purpose for quashing some of the subpoenas were?
No.
Well, I'm curious, because maybe I should go back and watch it if they have it, but I'm curious because that should have been done first before they had their evidentiary hearing or whatever that was done on the day he was dragging Bradley into the courtroom. Because if they had done that first, then they would have had some of the witnesses at least compelled to the courtroom to testify, and perhaps they could have proven it was institutional.
Well, the judge ruled that it wasn't institutional. So because the evidence, whatever evidence he saw, told him that the higher ups told them to be honest in court. There's nothing, apparently there's no evidence saying that they said cover this up, hush it up, you know, don't do it.
So sitting on it for a year isn't a cover up. Bullshit. Not filing Brady for a year when you know the lead investigator is under investigation and has a problem, that's bullshit. Period. I don't know how anybody comes to the conclusion that that's not an institutional fuck up at the very least, let alone a cover up. It is a cover up. Sorry. That's crazy. So whatever. I guess the state wins again.
Oh, you have such a dark outlook on things, Megan.
But that's what it is. That's what we're watching happen. The state And the judge, by the way, works for the state. Don't give me this, unbiased bullshit that they want to say the judges are all, unbiased. Baloney. The judges are biased towards the state almost 100% of the time. They get paid by the state. They go to golf with the state. They go to dinners with the state. Sorry, it's garbage. Why are you smiling?
Are you okay, Megan?
No, I'm not okay when the state gets to put its jackboot on the necks of the public. I'm not okay with that. I'm never going to be okay with that. And I want to see somebody pay, God damn it. And I want it to be a prosecutor. I want her to be strung up in the public square and caned. That's what I want. I want her to be put on one of those things that, the rack that pulls you apart. That's what I want to see. I'm done with this. I'm tired of it. I'm tired of state officials with the power to take away your liberty, getting nothing but a slap on the wrist, if even that. Bradley didn't even get a slap on the wrist for this. She didn't even get a public dressing down by the judge. We didn't even get that. This is bullshit.
But that's not what the judge does. It's not the judge doesn't reprimand the prosecutor. That he doesn't take away her license. He doesn't punish her.
He could tell her that what she did is reprehensible and that he's ashamed that she's practicing law in his courtroom, and he could refer her to the bar. He does have that power. He does. He could sanction her. He could put her in jail if he wanted to. I've seen judges put people in jail for absolutely freaking nothing. He could have definitely given her 30 days in the pokey for this.
For what?
For lying, for sitting on a Brady document for a year, for fucking up this trial, for anything he wants. I've seen judges do things that you can't even believe, that is completely out of the scope of but they have total immunity. They can do whatever they want. He can do whatever he wants. And I've seen it. Judges are basically gods in black robes. So the idea that, he can't, he's restrained. Really? He's restrained? I've seen judges do things that would make your toes curl. He's not restrained. He's just not doing it. He's not using the power of the bench. That day when they didn't show up for subpoena, he could have ruled immediately. I ruled against your motion to quash, and now I'm going to send the sheriff to drag all 17 of those people in here. They're going to sit outside in the hallway. I'm going to take their phones. They're not allowed to speak to one another. The sheriff will watch them, and we're going to take each one of their testimonies right now and get to the bottom of it. But he didn't do that. He didn't even fuck.
What?
Hi,
What?
Steve.
Hello, do you hear me?
Hi, Steve. We can.
Yes.
We're trying to talk Megan off a cliff.
I know. It's okay. Everything.
Speak
You're a
gently
good
to me,
person.
Steve.
I love you both. And I've only got a few minutes because I promised Laid Back News that I'd be on at noon. I'm taking a jihad holiday today. So because I've got so many streams lined up today.
Mm-hmm.
And I'm going to have an 8 o'clock stream, a pre-F It Friday 8 o'clock stream on my channel, and we'll dump into you at 9 o'clock. So,
well, awesome. Let's get to the bottom of this here.
I have offered.
Let's take Megan off the cliff. We don't want her to jump.
Emailed the 17th Judicial Circuit. Given the right remuneration, I will accept their offer to pick up this case and try it beginning next Monday. I am board certified criminal trial lawyer in Florida. I will not pursue the death penalty. I will pursue a life in prison crime, but I will get them off the ledge. And if they meet my conditions, I will quit my job immediately, travel to South Florida, rent a hotel room, and do nothing for the next 3 weeks but handle this case, handle every motion, pick their jury, and handle their trial front to back. And
well, I'm going to send Megan off the cliff again here.
That is a legitimate offer, so that they can say
that
they have options. They have options. I am fully qualified to do exactly what I'm saying.
For those of you that don't know, Steve is an assistant public defender with the appellate division there in Florida, and he has death penalty experience.
But I will not pursue the death penalty.
And he's written books.
I would drop the death penalty. I would pursue life in prison only. I would pick the jury. I would try the case. I would familiarize myself. I'd handle all the motions. I'm just telling that this state attorney's office, if they
I want to pick your brain here, Steve, in the limited time we have.
Yes.
I'm going to send Megan off the cliff again by saying I think this judge is being fair. This judge is a very good judge, and I think he's being
insane?
Actually favorable to the defense.
Are you crazy?
Hey, Fox, look, listen, everything's cool. He took it under advisement. That means he has not yet ruled.
It means he's
Number
not
two
gonna,
is
he's not going to do it.
Number two is that he has not ruled everything. Everything's fine. He is taking a very dramatic step already, which is to disqualify the state attorney's office, which was entirely appropriate.
Not the office, just that one bitch.
Well, everybody except for like 3 or 4 people.
Yeah.
Like the highest people there. You know.
Wait, I thought you said he just removed Bradley.
No, she was the lead attorney on the case. She's off the case, and the other people, the 3 or 4 that that were mentioned in the article we read at the beginning, they're the ones that have not been called in to testify or have not been put on notice. That the higher ups, they're saying that it doesn't go to the highest levels.
It seems to me that the entire state attorney's office should be disqualified.
Yes.
And in that case, they need to bring in a special prosecutor for this case.
That's what should have happened.
Yes.
That's
and
so
I'm
don't tell me
available.
he's being fair. They needed to have brought in a special. If they're going to retry this, it has to be a special prosecutor that has no connection to any of these fucknuts who
I have
screwed
no
all of this up.
connection to either party. I don't know the judge. I don't know the
I vote for
prosecutor, I don't know
Steve.
the defense.
Hashtag hire Steve Gosney.
Hire
No,
Steve Gosney.
But that's what I would have done too, and that's what I think is fair. But what the judge did does not mean he's a terrible judge. He's biased for the prosecution. And he's trying to railroad the defendant.
He made a very good ruling on that. I expect if because the state made the representation that there was no material harm by the tainting of this one witness, which is the lead detective. So I will take the state at their word, and the remedy for this Brady violation and this Giglio violation should be to exclude that witness from testifying in the retrial.
Yep.
Which means it would be a 5-minute trial, and they've got nothing to offer, and it's over.
But the state has represented that the harm was not material. So if they're bound by that statement, they are representing that to the court. Do it. And I would say also that Miss Megan Fox, the law tube mom of the law tube,
the angry mom who wants to ground everybody.
I do.
I will say that the Florida bar has reforms in which you, as an interested citizen, can report anybody you wish to the Florida bar's ethical proceeding. Now I put some statistics in, but most people don't. A lot of people don't read the chat; they're just listening. If you look at ideas and answers in law on page, get out your books, on page 240.
All right, let's see.
On page 240, it says a modest search of disciplinary cases reveals that only 6 times in the last 3 decades, where the Florida bar has sanctioned a prosecutor for action in relation to the prosecution function. That means for the last 30 years, only 6 prosecutors have been sanctioned by the Florida bar. And I will tell you, of those 6, 3 of them, 2 of them remain prosecutors and are prosecutors to this day. A third one that I'm familiar with was a capital trial attorney. He was not removed. He retained his job, but left voluntarily after a few years. Now he's with Morgan & Morgan. The fourth of the 6 became a judge. And the other 2, I'm not.
You're not helping calm her down, Steve.
Of course.
So I'm saying that the forms are available for reporting this. You have all the
bullshit has to stop. It has to stop. And I'm sorry, Jeff, I disagree with you that the judge is not showing a bias towards the state. Because for the very reason that Steve mentioned, What should have been done here is a special prosecutor should have been appointed. The entire office should be kicked off of this case. No one who worked with Bradley, who came in contact with Bradley, who supervises Bradley, none of those people should be involved in this case.
That's right. So they need to have they need to hire somebody out just for because the appearance of impropriety on any conviction would be a problem. So they need to hire somebody from outside the area who is fully qualified to try this case, who is willing to quit their job today, drive down to South Florida, rent a hotel room, be familiar, go review that whole thing. And there aren't many attorneys, not only that are willing to do that, that can do it, that review. I've reviewed over records of over 12,000 pages. So I am I'm the only person probably in the state that could do what they're asking. And I think because they have the appearance of impropriety, that's like a cloud over their office. They need to dispel that cloud by
get rid of the whole damn
get rid of that
office.
Prosecutor, reporting her to the Florida bar, making sure she doesn't practice again, and bringing in an outside special prosecutor for this case. I think it's a great, and I have sent an email to the prosecutor's office.
Oh, good.
To give them this very generous offer, and I've also informed.
Should I publish your letter? You want to send me your letter? I'll publish it on
It was
PJ
by
Media
email.
as a news story. Lawyer,
it's
Steve. Lawyer offers to try Melly case because of let's see.
Absolutely.
Because of disgraced prosecutor's office.
You can absolutely, and I've also sent an email to the defense attorneys so that if the prosecutors complain that they can't find anybody to pick this up, that they have a counter, that they know that there's a special prosecutor in the wings waiting to be hired for this very subject. Now, I'm not saying that we've agreed on price. I'm just saying that it's capable. And I will also note that there was a recent death penalty case that I was watching in which the state paid one expert witness, $270,000 on the death penalty case. And it was a first-degree murder death penalty case, and they only got a manslaughter. So if they're willing to put that kind of money in the face of trying to get somebody, I think that any price that I would name would be completely fair and reasonable. So I'm just laying it out there for it. I want this. And what more benevolent move could a state attorney's office make than to bring in me? Do you have any questions before I go over to laid back news? I'm sorry. I gotta.
And then one thing, like Hempel in Texas here is saying, do you really think they can have a jury set by the deadline? They just need to swear in the potential jurors by the deadline.
Exactly. They need to begin the voir dire. In fact, I'm also an expert on the speedy trial rule. And that's right. They need to begin.
My question is, what do you think about the state's attempt to do an end run around the speedy trial by saying, let's swear in the potential jurors on Wednesday and then just tell them to come back at some other point in the future when we're ready for them? So we can hold all these hearings. We can take all the.
Right. Well,
that's what he suggested. Bring all 250 of them in, swear them in. Oh,
I've got an appointment I'm late for. I got to run.
Oh,
sorry. See you later.
Thanks, Megan. We'll calm you down later. Bye. And Steve's got to run too, so it looks like we're wrapped. You got about 5 more minutes, then I'll be joining you over there.
But F it Friday tonight, man. I'm ready.
Yes.
And I've got my alcohol ready to go, and I'm going to have an 8 o'clock pre-stream on ammunition stockpiling suggestions.
Cool.
As well as death penalty and how that integrates with the rule of law versus the lack of rule of law situations, and how somebody like Gosney here can support a deadly use of force in self-defense or in a warfare context. So we're going to talk about, have some ideas on that we'll talk. And then we'll dump at 9 o'clock. They'll dump over into Mr. Legal Vice's F it Friday stream, and I'll be there and we'll have a party.
Sounds good to me.
But was there a question about the speedy trial rules? Very complex.
Well, Sam, that was the thing, is the state's suggestion to avoid the speedy trial issue is to bring all 250 of the potential jurors in on Wednesday, swear them into potential jurors, and then just send them home for an indeterminate amount of time while they take their time to go through all the depositions, all the motions, all the stuff they've got to get through. I think that's a cheap attempt to get around the speedy trial rule, and I don't think the judge is going to accept that.
Yes, I think you're right. There's a million ways to waive and get out of speedy trial. All right. It's a very complex statute. In fact, this might be the rare case where they might actually get some relief. I've seen speedy trial a lot. In fact, I'm working on a whole big module for Mr. Branca's American law courses on speedy trial. It's a full day of complexity. There's a constitutional speedy trial right, and there is a statutory speedy trial right. What is being dealt with right now is the Florida's statutory speedy trial right. That's the first thing you need to understand. It's a very complex rule, but yes, that is technically a way they could get around it. But it takes judge acquiescence, and it also there's a lot of hitches to that. For example, that you can't trick your way out of defeating the speedy trial rule. There's many cases, several cases I'd say, in Florida wherein the speedy trial is coming up and the state null process the case and then refiles it, and they try to beat speedy trial that way. And that was
the other suggestion. Why don't they just dismiss the charges and refile later?
No, that doesn't work.
Yeah, it doesn't work.
That's a trick that has been tried by prosecutors and does not work.
And I mean, that's the important thing is I don't know. Again, if they go on the Florida statutes, I have no idea what remedies are available, but it seems like any reason the prosecution would present for waiving or getting around the speedy trial would be because of something they did and would sort of nullify it.
It's almost impossible to get a dismissal. It takes a lot of prosecutorial effort to get a dismissal on speedy trial grounds. But, it's amazing because in Florida, our prosecutors seem to achieve this goal occasionally. And it's almost, if you read the statute, that it's so impossible for the prosecutor to lose, but yet they do it anyway. It shows you that they are just terrible over there and they need to work on their training.
Well, see, and that's where I was trying to talk Megan off the cliff is, yeah, okay, it'd be great. Just say, okay, never mind. It's all dismissed. Everybody, we're just going to let him go. First of all, the judge is going to be very, very hesitant to just drop charges against someone that's been charged with double murder.
The time hasn't occurred yet. So he's going to reserve ruling. If the state brings it to trial, he can always sanction for dismissal later. So if he lets the speedy trial rule dismiss the case, then he doesn't have to rule on sanctioning the prosecutor. So he wins.
Well,
right?
And he put them on notice because Morticia Adams, she said 23rd is the deadline, 24th we're filing our motion, and the judge told the prosecutor, she says she's going to file on the 24th. Should we go or we don't?
Right. So his problem, he may not have to rule on that motion because it may go away on its own through operation of speedy trial statute. So that would be ideal for him. Then he doesn't have to call all the prosecutors bad people, and he gets the case dismissed, which would be the sanction. Now, I think there's some interim sanctions which were probably appropriate in this case, and that would be to exclude the witness that was tampered with. I think that's a fair thing, and there's other remedies that you can go through that.
Well, even if they put him on the stand, they're going to just crucify him on credibility.
But the jury could still convict.
Yeah, sure. I mean, that's true. But and we got about 2 more minutes here, then we both have to run. If they would have uncovered this during the original trial, I think it would have been a dismissal with prejudice.
Well, the thing is that prejudice attaches when there's prosecutorial misconduct, which it seems like there is in this case.
Yeah.
Generally, the state can retry cases over and over and over again when they get hung juries. But in this case, when you have prosecutorial misconduct and the mistrial occurs because of that, then there's prejudice attached. So there's a lot of ways. I mean, the defense is doing a good job of holding the state to the fire. We'll see how it unfolds.
And similarly, if the jury had been sworn and then they had uncovered this, I think there would be a high likelihood for a dismissal with prejudice. But here, where they're in between the trials, there's no dismissal to be given. The remedy is a new trial, which is what they're working towards. So I think the judge is severely limited in the remedy he can give at this point. I mean, he could dismiss it,
He could
but
also
you know,
sanction. He could also sanction the case by taking the death penalty off. I think they did that. I forget which case it was out west somewhere. Pretty recently, there was a bunch of discovery.
yeah.
And I thought that was a pretty clever remedy for the prosecutor or for the judge to impose, and they should do that. Anyways, we got to get going.
All right. Well, Steve, we'll let you say goodbye, and then I'll say goodbye, and I'll see you over there in a minute. Give us your outro, Griff.
Friday tonight, 9:00, and a pre-up at Friday my stream at 8:00.
All right. That is Steve Gosney, lawyer extraordinaire from the great state of Florida, where all of this is going down. Now, where they're going to be back in court apparently on Tuesday of next week. They've got 30 motions to get through. And that's a lot of motions. It sounds like what the judge is going to do is he's going to go ahead with the trial, and they're going to have to pick and choose what motions they want to go to first. But what the judge has repeatedly said is, I need a prosecutor. Once we get the prosecutor, then we have to start these motions, and we can't start arguing these motions because the prosecutor's got to argue the motions, and there's no prosecutor here. Who is the prosecutor? We got to find one. It's going to take a while, but that's their problem. So he's given them till Monday to get the prosecutor lined up. Tuesday, he's going to start these motions, and they've got to get this jury sworn in. Probably, they said like the deadline was Monday, the 23rd. That's kind of, by that time, they have to at least start saying, these are our potential jurors, and swear them in as potential jurors. So next week's going to be a busy week. If they don't get through all 30 of these motions they need to get through, then like the judge was talking about doing Monday, Tuesday, Wednesday, Thursday trial, and then using Friday for the motions. So we'll have to see how this goes. I get Megan's anger. I'm there, but the realities and the practicalities that the judge just can't start throwing everybody in jail. I wish they could. That would be awesome if they could. But then that would be a judge overstepping their bounds. So I get the anger. I feel the anger, but the anger, there's only so much that can be done within the legal framework, within the judge's power. If the judge said turn these over and they didn't turn them over, then there would be the grounds for the sanctions. There would be grounds for punitive, for penalties against the prosecutors. There would be grounds for contempt, things like that. But they absolutely can't. Don't lie. I'm not lying. The judge just can't say, oh, you sat on this evidence, you have to go to jail. They can't do that. That's just not what they do. That they literally can't do that. As much as you want them to, but they literally can't. But we're going to go through this. We're going to cover it as much as we can. And once the trial starts, we'll go gavel to gavel. They're estimating that once the jury, once the potential jurors get sworn in as potential jurors, they're estimating that seating the jury is going to take about 2 months. So they're looking to hopefully start by the end of November, first part of December with the actual testimony. And once that gets going, we will do gavel to gavel coverage as we did with the first trial. That's where we stand now. We'll keep you posted on how things go. Again, big motions by the judge, big movements to take the lead prosecutor off the case. And that really, really hampers the prosecutor, the prosecution, because she knew everything about the trial. She's took it from square one all the way up to now. And there's no one that knows the case like she does. And the judge just said, you got 3 days to work this shit out. So this new prosecutor is going to come in without a full knowledge and an over familiarity with the evidence. That's really going to hamstring the prosecutor. They've got a shitty witness with the lead prosecutor, with the lead detective, who is either not going to testify, is not going to be allowed to testify, or is going to get crucified on credibility. Another huge, huge win for the prosecution there. And anything bad that happens to the prosecution at this point, they earned it. They deserved it. And the judge is going to make his ruling on the motion to dismiss after he looks at the internal affairs reports and the other transcripts. Again, he's not going to dismiss the case. So we're gonna have to go forward on that basis. They have time because of jury selection. Well, they're going to be selecting the jury once jury selection starts. That's the time. The speedy trial deadline is the deadline they have to swear in the potential jurors, not swear in the final jurors as jurors on the case, swear in the potential jurors to be considered for jury. So yeah, that's the deadline. And then once that happens, they're moving on. But that's what the prosecutor's trying to do to get around this, saying, well, let's bring all the 250 jurors in. Let's swear them in as potential jurors. And then we can just make them wait while we do all this other stuff. And the judge said, yeah, you're not wrong with that suggestion. It's a possibility, but don't think it's going to go your way necessarily. Let's find out what happens. Tuesday, there'll be some answers. So if any answers come in before Tuesday, we'll let you know. Tuesday, we'll see what there is to cover. Oh yeah, okay. Ray says, sorry, that's not what I meant. I mean, they have time to familiarize themselves with the case because the jury selection takes 2 months. They're going to be busy worrying about jury selection, but they are going to have a little bit of time, but not enough time to familiarize themselves with all of these. It's still going to be a hamper for the prosecution. It is a disadvantage for them. So let's see what happens. Let's wait for Tuesday and see where we sit. Right now, I just want to say super special thanks to all of the mods for sticking through this. You guys are awesome. You guys rock. And let's see. Chat, we got 621 of you still here. We got over, what do we get? We got 643 likes. That's awesome. Thank you so much for that. 12 new members out of this. Jojo, welcome to the Clean and Sober crew. You are our newest member. And what do we got here? John Gordon with the $5 super chat. Megan sounds like my mother when she's angry because she's the internet's mom. She's definitely the law tube mom. It could be the entire internet's mom if we let her. Let's see here. Want to just go back through a couple of these things, see if right. I guess that takes care of everything. Still considering the Krasuski trial. I wonder where that is. I haven't checked on the Krasuski, on the Krzyzewski trial. However she wants to pronounce her name, the Krzyzewski trial. That's how it should be. I always call it, Coach Extraordinary Krzyzewski. I always called him Coach Krasuski, but that's just a thing. So now anybody with a Polish name just automatically gets called Krasuski by me. So the Krzyzewski. I don't know where we were sitting in that trial. I haven't checked on it for a while. We'll have to check. We'll have to do an update on that. See what happened. But that's where we are. Join me in what 2, 3, 4, 5, 6, 7, 8, 9 hours. 9 hours from now. I think 9 hours. 2 o'clock. 3, 4, 5, 6, 7, 8, 9. No, 9 hours. 9 hours. Yeah, 9 hours from now. 9 hours from now will be my Fuck It Friday stream where we say fuck it. We just bring on a huge panel of guests. They come and go as they please. It's just a huge panel show. We got about 23, 24 potential people coming in, all superstars, all great law tubers, extraordinary. And other people will be filing in as space permits throughout the night. It's a griftathon. Bring all your money, throw it at me. We do $100 shots. It's just the one time. We just grift hard once a month, so we don't have to do it the rest of the month. It's fun. It's all fun and games. So that starts 9 hours from now. Bring your super chat money and throw it at me, and let's see how much trouble we can get into and how long it takes for my liver to give out. Vice Squad chat, all of you in chat right now, all 581 of you are the greatest chat on the entire internet. So thank you so much for being here. Thank you for your support. We'll see you all in about 9 hours for Fuck It Friday. Friday the 13th, Halloween 2023 edition. Yes, it'll be Saturday morning at 10 a.m. is when I'm going to start my drinking because that's how I roll. So take care, everybody. I'm going to funnel us over now to Laid Back News where Steve Gosney and others are already in progress. Let me do this real quickly here. Bear with me for another minute. Don't go anywhere. You're not going to want to miss this. So hang tight, please. While we go to the studio, we pull up the content. Today's content live. Where are we? Live stream. There we are. And bring that up. Go to customization. I'm doing this live right here with everybody. Redirect. Go to Laid Back News, Friday the 13th edition. There we go. We are locked in and saved. And by the way, We got about 20 subscribers out of this. So if you're one of the subscribers that just subscribed during the course of this, love you guys. Thank you. Stick around for more Melly. Until then, make sure you go and prepare your bank account for Bucket Friday. The grip starts now. Take care. Enjoy your legal vices. I am Legal Vices, the Law Rex, saying out.